Live from Washington, NPAC brings you gavel-to-gavel coverage of the House Judiciary Committee proceedings. Tonight, impeachment debate, July 24th, 1974. Here is NPAC correspondent Jim Lehrer.
Good evening. July 24, 1974. Another one of those days of history to save the front page of your newspaper to remember what you had for lunch. Because in a few moments, the House Judiciary Committee will begin its formal public debate and voting on articles of impeachment against President Richard Nixon. Only the second time in the nation's 200 years that any move against a president has gotten this far has been this serious. And if that wasn't enough in itself, it comes tonight in an atmosphere punctuated by a ruling earlier today from the U.S. Supreme Court ordering the president to turn over evidence to a federal district court. The vote by the High Court was 8-0. And just a few moments ago, President Nixon said through his attorney that he would comply fully with the Supreme Court's ruling to surrender 64 Watergate tapes and documents to Judge John Sirica here in Washington. James St. Clair read a statement from the Western White House saying that the president was, quote, of course, disappointed, end quote, with the court's ruling. But St. Clair read, quote, I respect the court and will comply in all respects, end quote. It all ties together. It is all interwoven. A momentum toward a climax of a fitful 2 years, which began when 5 men broke into an office building here in Washington called the Watergate.
I'm Paul Duke. Beginning tonight and continuing for the next several days, Jim and I in the PBS system will be bringing you gavel-to-gavel coverage of the historic proceedings now taking place before the House Judiciary Committee. In a way, this is the moment of truth for the 38 members of that committee. They have now heard the evidence, they have listened to the tapes, they have read the transcripts, they have questioned John Dean and the other witnesses. Now they must make their fateful decision. It's expected the committee will recommend impeachment, perhaps by a substantial margin. In the past few days, key members have been quietly meeting to draft language for at least 2 or more articles of impeachment. We, of course, do not know the form that the impeachment resolution will take, but the impeachment articles are expected to embrace at least 3 charges against the president: that he obstructed justice in the Watergate case, that he has widely abused his presidential authority, and that he has shown contempt for Congress by refusing to turn over evidence sought by the Judiciary Committee. Our Capitol Hill reporter, Carolyn Lewis, has been covering the committee's deliberations lo these many months, and she is now standing by, waiting expectantly, outside the committee room. Carolyn, could you tell us precisely what the committee is going to do, how it's going to go about its business tonight?
Paul, the committee has set aside some 10 hours for debate, general debate, and we expect that they'll use up some 3 of those hours this evening. At the opening of the session, Chairman Peter Rodino will make a statement about 15 minutes long, and then he'll recognize the ranking Republican, Edward Hutchinson, who will make a statement of his own. During these opening hours, no member will be allowed to speak for longer than 15 minutes. Anyone who wants to use less time can yield the remainder to his colleagues. The plan is to recognize members in order of seniority, alternating Democrats and Republicans. Under the rules adopted last night, there could be some interruptions, with one congressman asking another to yield. On the whole, these early hours are likely to be very solemn, dealing with broad issues with an overview, and very much formalized and structured. The idea here is to give each member of the Judiciary Committee his moment in the spotlight, his moment in court, so to speak, before getting down to the business of defining specific articles of impeachment. Jim?
All right, thank you, Carolyn. With Paul and me tonight to comment on the immediate as well as the long-range effects of what's happening in that committee room is the distinguished historian and author, Barbara Tuchman. Mrs. Tuchman is the author of several books on recent world history, including The Guns of August and The Proud Tower. She has won 2 Pulitzer Prizes for her writings in history. Mrs. Tuchman, what are your thoughts as we prepare to embark on this Judiciary Committee debate? How would you classify it in terms of history?
Well, I think the first thing that I'm thinking about is the opportunity for the House of Representatives and for the Congress to retrieve the role that the Constitution gave it, and that has eroded so dangerously over the last 30 years. I think in a way, in a sense, it's the Congress that is as much, if not on trial, at least facing a serious moment in its history as much as the presidency, because it seems to me that through its faults of omission over the last 3 decades, it is the Congress that has allowed the abuse of power by the presidency. And it's time we got it back. And I hope, I think the significance for the American people is in the action of the House, first of all, as much as what will happen in relation to the presidency.
Well, are you suggesting, rather subtly, Mrs. Tuckman, that you believe that this is a kind of last chance for Congress to stop the erosion of its own power and to impede the flow of power toward the White House, which has occurred in recent years?
Well, I'm not given to very dogmatic statements about first, last, and never, but I think it's a terribly important opportunity, and I have been, as an American citizen, concerned by the tipping of power in the executive, to the executive, for so long, because I am not, I think like most of us, not an advocate of one-man rule, and our democratic system has been, I think, not through evil intent, but through circumstance, tipping way over toward one side in a way that has become dangerous for the outcome of democratic government.
Mrs. Tuckman, the assumption always is, of course, that a historian's eye is different than the layman's eye. What specifically are you going to be looking for tonight as you watch this debate? Any particular thing, just the words that you might hear or whatever?
Well, I was hoping to hear some statements of a sense by the committee that they represent the citizenry of this country, because after all, that's what a House of Representatives is. It represents the citizens. And I felt, I never lose my capacity to be shocked. I always thought I could. But I really was surprised, if not shocked, by the Republican statement of 2 days ago about, or was it yesterday, about Mr. Jenner and his not carrying out the functions for his client, because I am really puzzled by the Republican, by their equating the retention of Mr. Nixon in the presidency with the, sorry.
Yeah. Well, let's go back to Carolyn Lewis for a moment, Ms. Tuckman. Of course, Ms. Tuckman will be with us throughout the evening when there are breaks, and of course at the close of the program. Let's go to Carolyn Lewis for some reaction from the committee members to the President's decision a few moments ago. Carolyn?
Jim, the general reaction is a feeling of relief. I think that the President, by his action, has avoided what you might call instant impeachment. The feeling on the Hill, both in the Senate and the House, and that's very significant, was that if the President chose to defy the High Court, he would be instantly impeached. That they all generally agreed would be an impeachable offense. So the President has given them a feeling of relief. Now, the real question that's rising now is the timing. If you noticed, Mr. St. Clair said that this could be a time-consuming process, and that, of course, may be a tip-off that the White House may seek to delay. It may say that it can't get together all the materials, and, of course, this could affect the entire impeachment process. But the members that we've had a chance to talk to here have all said that they want no delay in these proceedings, that they do want the proceedings to continue, and if new evidence is made available to the House Judiciary Committee or to the full House, they can be inserted into the record. So as far as we've been able to discern, the general feeling is that this should not delay the proceedings. Now, I understand that there have been some members who have said that they may try to delay them, but I think the general consensus is no. They're just going to carry on regardless. Back to you now, Jim.
Carolyn, there's another question which I would like to put to you. Carolyn, are you still there?
Yes.
I would like to ask you whether there is any indication from some of the Republican members, perhaps, that the president might now go a step further and turn over the tapes or copies of the tapes or transcripts to the Judiciary Committee as well. One of the leading Republican members on that committee, as you know, is Charles Wiggins of California, and he has suggested only today that perhaps the White House might do this. Is there any indication that this might be done?
Paul, we've had no indication of that, but there was something very interesting that happened about a half an hour ago here. That is before St. Clair actually spoke, so it's over a half an hour. The Vice President, Gerald Ford, looking very, very grim, came to the Hill and came upstairs just one floor above where I'm standing right now, and he went into the office of Congressman Glenn Davis and there met with a number of Republican members of the House Judiciary Committee. Now, nobody is saying exactly what the Vice President said, but he was looking very, very grim. Now, it may have been an offer of more information. At this point, I'm afraid we just can't tell. There hasn't been time to pin that one down, but we'll work on it.
Carolyn,
well, thank you, Carolyn. We'll be coming back to you in just a moment. I'd like to say that the chairman of the committee, Peter Rodino, is now taking his seat, and we expect him momentarily to bang the gavel, which means that tonight's historic debate will be getting underway momentarily. We see that most of the committee members now appear to have taken their seats.
Yes, please let
Chairman Rodino.
Gano and we want to.
Paul, I think we need to point out very quickly that the fact that these tapes and documents will be turned over to the federal court, there still could be a process by which is still undecided as to how they would finally get to the House Judiciary Committee. I mean, the fact that they're going to the court does not automatically mean that they're going to the House Judiciary Committee. That would have to be resolved as it goes along.
Yes, I think the point that Congressman Wiggins was making today, Jim, was that he hoped the White House might voluntarily turn over the tapes at the same time that he was providing the information for the courts as well. In other words, this would be an indication that the White House was now willing to provide more evidence to the Judiciary Committee.
And of course, this would lend great impetus, I would think, to delaying this particular process until those tapes have been given to the committee through one way or another, and they've had a chance to review them before they would go to this step of debating and voting on the articles of impeachment. It'll be interesting to see if Wiggins, particularly, who has been the president's primary defender on the most articulate, I would say, too, defender of the president on the committee, makes a strong effort tonight to delay it on that basis. As Carolyn says, as Carolyn just said, there will be, some effort along that line. Depends on how serious it is.
Well, we're still waiting for the proceedings to get underway, and it appears that they will start momentarily.
Get in here.
Mr. Rodino apparently now is waiting for the room to be cleared of photographers and cameramen who have been in to get just one more picture, as always. On either side of Mr. Rodino, there is Democratic Congressman Donahue of Massachusetts, and the ranking Republican, Mr. Hutchinson of Michigan, is on the other side.
To review what Carolyn laid out earlier, the current plan is for Chairman Rodino to make an opening statement followed by Mr. Hutchinson, and then follow seniority on a Democratic-Republican alternating basis from that point on. That is what they call a poised gavel, Paul.
That's a holding pattern.
Want to get again to that one?
I've got a 4-page statement. know what anybody's going to say.
Chairman Rodino, of course, is a liberal Democrat from New Jersey, believed to be a sure vote for impeachment. There is John Doerr, man on the right in the lighter suit and glasses, who is the staff counsel for the Democratic side. To his right was Sam Garrison, who is the new minority counsel replacing Albert Jenner a few days ago. Repeat, to continue on Peter Rodino, he is considered a sure vote for impeachment.
The committee
Here we go.
will come to order. Before I begin, I hope you will allow me a personal reference. Throughout all of the painstaking proceedings of this committee, I, as the chairman, have been guided by a simple principle: the principle that the law must deal fairly with every man. For me, this is the oldest principle of democracy. It is this simple but great principle which enables man to live justly and in decency in a free society. It is now almost 15 centuries since the Emperor Justinian, from whose name the word justice is derived, established this principle for the free citizens of Rome. 7 centuries have now passed since the English barons proclaimed the same principle by compelling King John at the point of a sword to accept the great doctrine of Magna Carta, the doctrine that the king, like each of his subjects, was under God and the law. Almost 2 centuries ago, the founding fathers of the United States reaffirmed and refined this principle so that here all men are under the law and it is only the people who are sovereign. So speaks our Constitution. And it is under our Constitution, the supreme law of our land, that we proceed through the sole power of impeachment. We have reached the moment when we are ready to debate resolutions, whether or not the Committee on the Judiciary should recommend that the House of Representatives adopt articles calling for the impeachment of Richard M. Nixon. Make no mistake about it. This is a turning point, whatever we decide. Our judgment is not concerned with an individual, but with a system of constitutional government. It has been the history and the good fortune of the United States, ever since the founding fathers, that each generation of citizens and their officials have been, within tolerable limits, faithful custodians of the Constitution and of the rule of law. For almost 200 years, every generation of Americans has taken care to preserve our system and the integrity of our institutions against the particular pressures and emergencies to which every time is subject. This committee must now decide a question of the highest constitutional importance. For more than 2 years, there have been serious allegations by people of good faith and sound intelligence that the President, Richard M. Nixon, has committed grave and systematic violations of the Constitution. Last October, In the belief that such violations had in fact occurred, a number of impeachment resolutions were introduced by members of the House and referred to our committee by the Speaker. On February 6th, the House of Representatives, by a vote of 410 to 4, authorized and directed the Committee on the Judiciary to investigate whether sufficient grounds exist to impeach Richard M. Nixon, President of the United States. The Constitution specifies that the grounds for impeachment shall be not partisan consideration, but evidence of treason, bribery, or other high crimes and misdemeanors. Since the Constitution vests the sole power of impeachment in the House of Representatives, it falls to the Judiciary Committee to understand even more precisely what high crimes and misdemeanors might mean in terms of the Constitution and the facts before us in our time. The Founding Fathers clearly did not mean that a president might be impeached for mistakes, even serious mistakes, which he might commit in the faithful execution of his office. By high crimes and misdemeanors, they meant offenses more definitely incompatible with the Constitution. The Founding Fathers, with their recent experience of monarchy and their determination that government be accountable and lawful, wrote into the Constitution a special oath that the President, and only the President, must take at his inauguration. And in that oath, the President swears that he will take care that the laws be faithfully executed. The Judiciary Committee has for 7 months investigated whether or not the President has seriously abused his power in violation of that oath and the public trust embodied in it. We have investigated fully and completely what within our Constitution and traditions would be grounds for impeachment. For the past 10 weeks, we have listened to the presentation of evidence in documentary form, to tape recordings of 19 presidential conversations, and to the testimony of 9 witnesses called before the entire committee. We have provided a fair opportunity for the President's counsel to present the views of the President to this committee. We have taken care to preserve the integrity of the process in which we are now engaged. We have deliberated, we have been patient, we have been fair. Now the American people, the House of Representatives, and the Constitution, and the whole history of our republic demand that we make up our minds. As the English statesman Edmund Burke said during an impeachment trial in 1788, it is by this tribunal that statesmen who abuse their power are accused by statesmen and tried by statesmen, not upon the niceties of a narrow jurisprudence, but upon the enlarged and solid principles of state morality. Under the Constitution and under our authorization from the House of Representatives, this inquiry is neither a court of law nor a partisan proceeding. It is an inquiry which must result in a decision, a judgment based on facts which must stand for all time. In his statement of April 30th, 1972, President Nixon told the American people that he had been deceived by subordinates into believing that none of the members of his administration or his personal campaign committee were implicated in the Watergate break-in, and that none had participated in efforts to cover up that illegal activity. A critical question this committee must now decide is whether the President was deceived by his closest political associates, or whether they were in fact carrying out his policies and decisions. This question must be decided one way or the other. It must be decided whether the President was deceived by his subordinates into believing that his personal agents and key political associates had not been engaged in a systematic cover-up of the illegal political intelligence operation, of the identities of those responsible, and of the existence and scope of other related activities affecting the rights of citizens of these United States, or whether in fact Richard M. Nixon, in violation of the sacred obligation of his constitutional oath, has used the power of his high office for 2 years to cover up and conceal responsibility for the Watergate burglary and other activities of a similar nature. In short, the committee has to decide whether in his statement of April 30th and other public statements, the President was telling the truth to the American people, or whether that statement and other statements were part of a pattern of conduct designed not to take care that the laws were faithfully executed, but to impede their faithful execution for his political interest and on his behalf. There are other critical questions that must be decided. We must decide whether the President abused his power in the execution of his office. The great wisdom of our founders entrusted this process to the collective wisdom of many men. Each of those chosen to toil for the people at the great forge of democracy, the House of Representatives, has a responsibility to exercise independent judgment. I pray that we will each act with the wisdom that compels us in the end to be but decent men who seek only the truth. Let us be clear about this. No official, no concerned citizen, no representative, no member of this committee welcomes an impeachment proceeding. No one welcomes the day when there has been such a crisis of concern that he must decide whether high crimes and misdemeanors, serious abuses of official power, or violations of public trust have in fact occurred. Let us also be clear. Our own public trust, our own commitment to the Constitution is being put to the test. Such tests, historically, have come to the awareness of most peoples too late, when their rights and freedoms under law were already so far in jeopardy and eroded that it was no longer in the people's power to restore constitutional government by democratic means. So let us go forward. Let us go forward into this debate with goodwill, with honor and decency, and with respect for the views of one another. Whatever we now decide, we must have the integrity and the decency, the will and the courage to decide rightly. Let us leave the Constitution as unimpaired for our children as our predecessors left it for us. I now recognize the gentleman from Michigan.
Thank you, Mr. Chairman. I certainly agree with the opening paragraphs of your statement, and I want to compliment you upon a statement in which I'm sure you hold strong and firm belief. Although I would disagree with parts of it, I certainly wanted to say that I certainly compliment you upon its opening several paragraphs. We now proceed to consider the large mass of evidentiary material which was assembled during many months and presented to us by committee staff and by the testimony of witnesses who appeared before us. During the next few days, we will be weighing the evidence and acting upon it. After a period of general debate, we will be discussing amendments and voting upon them. And finally, the end product of our deliberations will be manifest. Either we shall, by majority vote, have recommended one or more grounds for impeachment against the President, or all of those proposed for adoption will have been defeated. In our deliberations, the people will have an unusual glimpse into the discussions of those charged with decision-making in a unique judicial process. But perhaps ours is more of a political than a judicial function after all. The fact is that, of course, judges and juries deliberate behind closed doors. But by the committee's action in opening these discussions, it has in effect determined that our function is more political than judicial. I think the public should know that until now, the only decisions made by this committee have been procedural ones. No substantive matter has yet been resolved. Early in the inquiry, the staff submitted a memorandum on what constitutes an impeachable offense within the meaning of the Constitution. But the committee took no action upon it, it being recognized that no definition could be drawn which would be agreed to, probably by most members. Thus, as of this minute, the committee has not resolved just what an impeachable offense is. As the staff assembled evidence, many of us thought that the committee should decide and give some direction to the staff as to the scope of the inquiry. We thought the committee should direct the staff into those areas of inquiry in which the committee itself determined that there might be merit, so that time and effort would not be consumed in frivolous or otherwise non-meritorious allegations. But such a course of action would have required the committee to make decisions of substance, and no decisions were made. The articles of impeachment which are to be exhibited tonight are, like any legislative bill, merely a vehicle upon which the committee may work its will. They will be open to additions, to deletions, amendments, and substitutions. Each member of this committee individually weighing the evidence against his own concept of what warrants impeachment will come to his own conclusion on how he votes on the articles in their final form. Each of us is struck by the enormity of the decisions that we're called upon to make. As I see it, and I state only my personal views, a vote for an article of impeachment means that a member is convinced that the article states an offense for which the President should be removed from office, and that there is evidence which supports the charge beyond a reasonable doubt. Unlike criminal jurisprudence, where there is discretion in the court to make the sentence fit the crime, the Constitution mandates that conviction on impeachment shall carry with it removal from office, nothing less. It seems to me, then, that in determining in my own mind whether a specific charge states an impeachable offense, I would have to decide whether I thought the offense charged is of sufficient gravity to warrant removal of the President from office because of it. In other words, some offenses may be charged for which there is convincing evidence, and still such offenses may not, in the judgment of a member, be so serious as to justify impeachment and removal of a President of the United States from office. Earlier today, the Supreme Court announced that the President of the United States is required by law to comply with a certain subpoena ducis tecum served upon him in the case of the United States versus Mitchell and others by submission of the subpoenaed material to the trial judge for his private examination, and that the judge shall deliver to the prosecutor only those portions which are relevant to the case, returning the balance of the documentation to the President without disclosing its content. Since this committee has requested the tapes of the same conversations from the President and then subpoenaed them, the question arises whether our committee should proceed further until the availability of the additional evidence to the committee is determined. Many members on this side, Mr. Chairman, feel strongly that we should not. We believe the American people will expect us to examine and weigh all available evidence before we decide the momentous and most difficult issue before us. Even now, Mr. Chairman, we hope that the Chair will consider whether, in view of the events of today, the committee ought not first to determine to postpone consideration of articles of impeachment until the evidence now to become available through the court can be made available to this committee.
I recognize the gentleman from Massachusetts, Mr. Dono.
Thank you, Mr. Chairman. Pursuant to the procedural resolution which this committee adopted yesterday, I move that the committee report to the House a resolution, together with articles of impeachment, impeaching Richard M. Nixon, President of the United States. Now, a copy of this resolution is at the clerk's desk, and I understand a copy is also before each member.
I recognize the gentleman from Massachusetts for the purpose of general debate on his resolution for not to exceed 15 minutes, and every other member of the committee will be recognized for purposes of debate not to exceed 15 minutes, following Mr. Donohue's presentation. Mr. Donohue.
Thank you again, Mr. Chairman. This historic debate and the motion I have just offered to this committee have their roots in the most fundamental precept of free men, that no individual is above the law. On July 20th, 1787, the Constitutional Convention had before it the great question, quote, shall the executive be removable on impeachment? Mr. Governor Morris, a delegate to that convention, spoke out forcibly in opposition. He wanted no impeachment clause in the draft of our Constitution. But he listened intently, as first Benjamin Franklin and then James Madison argued on behalf of such a clause. And finally, just before the question was voted, Mr. Governor Morris announced that his opinion had been changed by the arguments presented in debate. The impeachment clause was adopted by the convention and became Section 4 of Article 2 of the Constitution of the United States. And the sole power of impeachment was vested in the House of Representatives under Article 1, Section 2 of the Constitution. Now, pursuant to that constitutional power, House Resolution 803, as stated by our distinguished chairman, was adopted by the House of Representatives on February 6th by a vote of 410 to 4. That resolution directed this committee to investigate fully and completely whether sufficient grounds exist for the House of Representatives to exercise its constitutional authority to impeach the President of the United States. For the past several months, as has also been stated, this committee has been continuously engaged in the careful conduct of this presidential impeachment inquiry. Under the absolute neutral leadership, I believe that our chairman has well established its overriding motivation of honesty, decency, thoroughness, and objectivity to the satisfaction of the great majority of the American citizens. Now, in truth, there were and there are no positive material instruments available to us, such as those by which we can measure a precise distance or pronounce the exact time of day, to guarantee the errorless performance of this duty. The human means through which we must try to make the right measurement of conduct that is required in this historical task exists only in the individual minds and consciences of each of the committee members. These are the basic resources by which each determines the substance and the culpability of, and in the evidence related to the several allegations that in the course of the official conduct of his office, President Richard M. Nixon engaged in certain activities designed to obstruct justice, to unlawfully invade the constitutional rights of private citizens, to refuse compliance with the duly authorized and properly served subpoenas of a committee of the Congress, to misuse executive agencies for personal and political benefit, and that President Richard M. Nixon, in other and diverse ways, failed to fulfill his constitutional obligations to ensure the faithful execution of our laws. Now, the awesome constitutional duty of each member of this committee is to make an impartial determination as to whether or not the evidence before us warrants a reasonable judgment that Richard M. Nixon as president, has seriously, gravely, purposefully, and persistently abused and misused the power entrusted in him by the people of these United States. Mr. Chairman, in my conviction, the hour for this decision has arrived. To this end, I believe the time has come to report to the House such resolutions, articles of impeachment, or other recommendations as we deem proper. On these enormous matters, I have carefully observed the witnesses who appeared before this committee, heard their testimony, listened to the summation of counsel on both sides, and I have fully studied all of the evidence. Mr. Chairman, I am most willing to listen to any further debate that may develop on the impeachment articles. I am prepared to vote on this momentous question before us. And I can but simply say this: my vote will be conscientiously cast in what I most sincerely believe is in the best interest of my country. I reserve the balance of my time, Mr. Chairman.
The gentleman is advised that while he has 15 minutes remaining, the rule has, while he has 15 minutes, the chair has to state that according to the proceedings and according to the policy that we have adopted, that no time would be reserved. And therefore, I now recognize the gentleman from Illinois, Mr. McClory, for 15 minutes for purposes of debate only.
Thank you, Mr. Chairman. I judge from the remarks of the gentleman from Massachusetts that indeed he has come to a resolution of this momentous question that's before us. Nevertheless, Mr. Chairman, let me express the view that this impeachment inquiry undertaken by our House Judiciary Committee has been both historic and honorable. Impeachment is, of course, a political process, both political in the sense of governmental action and political in that it involves partisan interests and views. It would be the grossest understatement on my part to suggest that Watergate and all that that word implies has not caused serious injury to my party, the Republican Party. And this is so despite the fact that no element of our established Republican Party organization was involved, and no Republican member of the Congress has in any way been implicated in this whole affair. Let me assert, on the contrary, that Republicans, even more than Democrats, are anxious to erase this blemish from our party. I've heard it said by some that they cannot understand how a Republican could vote to impeach a Republican president. Let me hasten to assert that that argument demeans my role here. It would infer that no matter what high crimes and misdemeanors might have been committed, that if attributable to a Republican president, then I, as a Republican, am foreclosed from judging the merits of the case. I cannot and do not envision my role in that dim light. As a purely partisan matter, would it enhance our Republican Party if, despite the evidence and the weight of constitutional law, we as Republicans on this side of the aisle decide to exonerate a Republican president accused of high crimes and misdemeanors simply because he and we are Republicans? I see that line as leading to Republican Party disaster. A viable two-party system, to my mind, is an institution worthy of preserving, second only to our constitutional system of checks and balances. Preserving our Republican Party does not, to my mind, imply that we must preserve and justify a man in office who would deliberately and arbitrarily defy the legal processes of the Congress, nor can our party be enhanced if we, as Republican members of the United States House of Representatives, tolerate the flouting of our laws by a president who is constitutionally charged with seeing to that the laws are faithfully executed as provided in Article 2. We will enhance our Republican Party and assure a viable two-party system only if we are courageous enough and wise enough to reject such conduct, even if attributed to a Republican president. The essential question which we must answer is not what is best for our party, but what is best for our nation. While the investigation has been far-reaching and has, in my opinion, delved into some peripheral areas, I cannot help but recognize that on the major subjects which have been investigated, the work of the committee and of our committee staff has been both objective and bipartisan. I would like particularly to observe that we've been assisted by able counsel, and to make a general observation that the members of the minority staff, the Republican staff, have contributed substantially to the overall work product of our inquiry. Despite our partisan differences, I would add that you, Mr. Chairman, have, in general, been very fair with the minority. The American public need have no fear that the Republican interests have not been ably and appropriately served by our ranking member, Mr. Ed Hutchinson of Michigan, and by my other distinguished and able colleagues who sit on the Republican side in this committee room. I shall turn at once to the main subject of our inquiry, namely the numerous allegations of wrongdoing charged against the President of the United States, all of which allegations we have investigated over a period of many months for the purpose of ascertaining whether or not President Nixon should be charged with the commission of an impeachable offense. The most serious allegations, and those upon which the President's accusers have placed principal reliance, go under the general title of Watergate and cover-up. Our majority counsel, Mr. Doar, in interpreting the information before us, has expounded the thesis that the President organized and managed the Watergate cover-up from the time of the break-in on June 17, 1972, up until the present time. While serious questions exist regarding the President's authorization or acquiescence in an obstruction of justice, a conclusion which might be reached from examining the transcripts of taped conversations and other evidence, the thesis advanced by Mr. Doar that the President was in charge of a cover-up from the time of the break-in is, in my opinion, unjustified in the light of the evidence presented to our committee. Our Chief Minority Counsel, the able Mr. Sam Garrison, made an important and extremely significant point in his final summation of the Watergate evidence. He said, Mr. Doar's case of circumstances showing presidential involvement from the beginning is a very, very weak one, because you cannot simply aggregate suspicions, you cannot aggregate inferences upon inferences, you can only aggregate facts. Watergate is a serious matter. Many in and out of the White House have been involved in this tragic episode. But while voluminous evidence has been produced, I question seriously that it is of the clear and convincing nature that should impel us to indict the President on a charge of cover-up or obstruction of justice. Instead, the case against the President rests upon circumstantial evidence, inferences, innuendos, and a generous measure of wishful thinking on the part of some who would indict the President even without adequate proof of wrongdoing in the Watergate affair. Now, in the light of today's Supreme Court decision, there may be indeed other available evidence to the committee within the next few days or weeks. Substantial additional evidence from the White House tapes upon which this committee can better judge the guilt or innocence of the President in the whole Watergate affair. The doctrine of absolute executive privilege upon which the President and his counsel relied has been substantially rejected by the Supreme Court. And we can expect, hopefully, that we will get promptly and without equivocation from the White House the additional tapes which we also subpoenaed and which are now under the President's decision to be made available to the special prosecutor. And we also have the mechanism for excising those irrelevant parts which might not be appropriate for us to see. Although on the basis of evidence thus far received, the case involving Watergate has been less than convincing, there are other subjects in which the facts are virtually undisputed, and where the only unsettled question is whether or not an impeachable offense has been committed under the Constitution, to which I made reference. If the extremely serious subject of Watergate results nevertheless in a weak case against the direct involvement of the President, this should not be construed to mean that there has been no wrongdoing in the White House. Watergate and the alleged cover-up involves the offense of obstruction of justice, for instance, payments of hush money, inducing witnesses to commit perjury, and others. These offenses have been committed at the White House or by the President's most intimate aides and friends. But if the President is not personally and criminally liable because the evidence does not directly and personally implicate him, nevertheless we may appropriately ask, has the President fulfilled his obligation to see to a faithful execution of the laws, a solemn obligation imposed by the Constitution? This obligation is above and beyond that of other citizens, all of whom are required to obey the laws. We may ask further, is the office of the presidency being operated in the manner contemplated by the Constitution when, under the guise of national security, dissatisfaction with the head of the FBI, or personal animosity against enemies, we experience burglaries, wiretaps, bugging, unlawfully provided, shredding and concealment of evidence, misuse of the CIA, FBI, IRS, and a host of other misdeeds? It should not be hard for my solid Midwest constituents, Republicans, Democrats, and independents alike, to see and understand what's troubling me. Believe me, it's also troubling them. The question remains whether these acts and omissions of Richard Nixon as president are to be approved or denounced. If in these respects the president is to be denounced, and if the president is to be called to account for such acts and omissions, impeachment is the appropriate and constitutionally designated vehicle for bringing these specific charges against him. What about the offenses committed by Haldeman, Ehrlichman, Colson, LaRue, Dean, and others? There is substantial authority for attributing their misconduct to the president in a strictly legal sense and require him to account for their offenses. But there is the higher constitutional obligation to see that such criminal acts are not committed or condoned, a constitutional demand to see that the laws are obeyed, particularly in the president's own house, which we call the White House. After receiving evidence for weeks and weeks, evidence which has been frequently peripheral as it relates to direct involvement of the president in Watergate and other crimes, I ask myself, is this any way to run a White House or a country? Finally, the clearest and most convincing issue before us, and one which is perhaps more fundamental to our inquiry, is that of the committee's subpoenas, in which we requested information from the President. Fundamental to the entire impeachment inquiry is his obligation to provide us with the information which requires so that we can perform our role. We do want a strong chief executive, but we also want a Congress which is given full recognition, as well as the courts. Likewise, it's essential that the President respect that part of the Constitution which vests in the House the sole power of impeachment. The House Judiciary Committee, as the designated unit of the House of Representatives, is endeavoring to fulfill that role with honor and dignity consistent with our responsibilities. In this particular time in our history, we demand a Congress capable of exercising not only its lawmaking authority, but also its power of the oversight function, which includes that of the extraordinary authority of impeachment. Earlier this year, the President promised full cooperation with our inquiry, consistent with his responsibilities to the office of the presidency. But despite that pledge, the only materials which we've received have come from the grand jury and from the special prosecutor, except some that have accidentally fallen into our hands. On May 30, we sent the President a letter advising him what the consequences were of his failure to comply. We said, in meeting our constitutional responsibility, the committee members will be free to consider whether your refusals in and of themselves might constitute a ground for impeachment. The committee has taken this stand because of the President's noncompliance with the committee's subpoenas, a defiance of the powers of the Congress, and impairing our ability to preserve, protect, and defend the Constitution of the United States. In this sense, it seems to me the President's failure to comply threatens the integrity of our impeachment process itself. His action is a direct challenge to the Congress in the exercise of its solemn constitutional duty. These, then, are the issues which are disturbing me as we approach this final phase of our assignment under the House resolution authorizing this comprehensive impeachment inquiry, which my colleagues and I have been conducting, and which we must resolve deliberately and responsibly within the next few days. Thank you, Mr. Chairman.
I recognize, for purposes of general debate, only the gentleman from Texas, Mr. Brooks, not to exceed 15 minutes.
Thank you very much, Mr. Chairman. This committee has heard evidence of governmental corruption unequaled in the history of the United States. The cover-up of crimes, obstructing the prosecution of criminals, surreptitious entries, wiretapping for political purposes, suspension of the civil liberties of every American, tax violations and personal enrichment at public expense, bribery and blackmail, flagrant misuse of the FBI, the CIA, and the IRS. 18 individuals have been convicted or pleaded guilty, and 6 have been indicted for criminal activities directly related to Mr. Nixon's re-election efforts or activities which originated within the White House. These individuals are not obscure government officials, but include cabinet officers, personal assistants, the closest personal advisors to Richard Nixon. Never in our 198 years have we had evidence of such rampant corruption in government. We must decide whether this corruption attached to the President, whether there is evidence that the President, by his actions or inaction, failed in his constitutional responsibility to faithfully execute the law. We on the committee, both Republicans and Democrats, have taken our constitutional responsibility most seriously and have pursued the facts, often without the cooperation of those possessing information, and at times in the face of planned efforts to mislead and divert us from the truth. It is our constitutional duty to determine whether there is sufficient cause to bring Richard Nixon before the United States Senate for trial and removal from office. In resolving this issue, we should put aside the legalistic jargon of our profession, present to the American people in plain language our best judgment as to whether there is evidence that Richard Nixon has brought disgrace and disrespect to the office of President. We must immediately put to rest the argument that the corruption we have witnessed in the last 5 years is only an extension of what has always been done. I do not share this view, or the view of those who hold that all presidents have lied, have broken the law, have compromised the Constitution. And if George Washington accepted bribes, it would not make bribery a virtue, nor would it be grounds for overlooking such acts by his successor. There is no political gain for anyone or any political party in this procedure. If ever there was a time to put aside partisanship, now is that time. There would be no democratic gain from removing a Republican president and having him replaced by another Republican who could represent and might well receive a great outflowing of support from our people. We must now report to the House of Representatives and the American people our conclusions as to whether there is sufficient evidence that Richard Nixon, while serving as president, has violated his oath of office and has thereby jeopardized our constitutional system of government. This is not a pleasant duty, but it is our constitutional duty. Its performance may mean ignoring personal and political relationships of long standing. But we, as well as the President, are on trial for how faithfully we fulfill our constitutional responsibilities. I want to thank the Chairman for recognizing me, and in the interest of expediting this resolution of this very difficult problem, yield the remainder of my time.
Recognize the gentleman from New York, Mr. Smith, not to exceed 15 minutes for purposes of debate only.
Mr. Chairman, ladies and gentlemen of the committee, I know that we all feel the weight of the historic action we are about to take. After months of diligent inquiry into the question of whether or not the President of the United States should be impeached, it is a solemn duty we have undertaken pursuant to the requirements of the Constitution of the United States. How we decide here, how the House of Representatives may decide if we recommend impeachment, how the Senate may resolve the issue if the House shall vote impeachment of the President, are decisions which will affect our nation in one way or another for the rest of time. I take this opportunity, Mr. Chairman, of expressing my respect for the other 37 lawyer members of this committee who have borne the grueling work of this inquiry for months. And I take this opportunity also to express my respect for and my thanks to the members of the impeachment inquiry staff and the regular staff members of this committee for the dedicated professional jobs each and every one of them has done during this historic project. The massive amount of information, documents, testimony, and legal precedents they have gathered, assimilated, organized, and presented with skill during these months of this inquiry are almost beyond belief. The constitutional duty of this committee in regard to impeachment, possibly that of the House and possibly that of the Senate, always a sad duty, is a particularly sad one here, in that it contemplates the possible impeachment and conviction of a president who has ended our direct participation in a bitter and divisive war which was not of his making, and who, history may show, has done more than any person now living to bring about peace and brotherhood in this world through his bold initiatives in establishing communication and bases for understanding with other powerful nations and other powerful peoples, and through his initiatives carried out by the painstaking and tireless work of dedicated aides in creating the climate for and the support of a real ceasefire in the Middle East and now in Cyprus. But even so, if this president has also been guilty of treason, bribery, or other high crimes and misdemeanors, as it is stated in the Constitution, then it is the constitutional duty of the House of Representatives to impeach him, and the constitutional duty of the Senate to convict him. To determine whether there are valid grounds for impeachment has been the duty of this committee. We have a resolution and articles of impeachment before us, and we have for months examined mountains of evidence and listened to witnesses. There is here no charge of treason, so the question is, do we think the President is guilty of the charges of bribery or other high crimes and misdemeanors? The President says he is not. What measure or standard of evidence is necessary for this committee to say he is or may be guilty? I think it is something more than probable cause, which is sufficient for indictment by a grand jury, and something less than satisfaction beyond a reasonable doubt, which is required for conviction of a crime. Mr. St. Clair, the President's lawyer, has suggested a standard of clear and convincing proof, and Mr. Dorr, the chief counsel of this committee's impeachment inquiry staff, appeared to endorse that standard. Except for one area, I am not satisfied that there has been produced before this committee clear and convincing proof of the President's personal involvement in actions which would be impeachable. The testimony is generally not solid and clear. It raises inference after inference, many negative ones against the President and some positive ones in his favor. But there is precious little solid, hard evidence of his personal impeachable misdeeds. Except for the area of the secret bombing in Cambodia at the President's order between March 18, 1969 and May 1, 1970, where I have not yet made up my mind, I should have to vote against impeachment of the President on the state of the evidence which we have seen. This is why I was delighted today when the Supreme Court ruled 8-0 that the President must deliver the tapes and memoranda subpoenaed by Special Prosecutor Jaworski. I believe that this means that this committee will at last have this material available for inspection, so we can determine once and for all whether the President is guilty of impeachable offenses or whether he is not. I think it is absolutely imperative that this committee make the effort to secure this evidence. I believe that any other course, in the present state of the evidence before this committee, would be self-defeating and not worthy of the effort which has already gone into this inquiry and investigation. And I thank you, Mr. Chairman, for recognizing me, and if my understanding of the reservation of time as of yesterday afternoon is still valid, I reserve the balance of my time.
I'd like to advise the gentleman, as I advised the gentleman from Massachusetts, that the policy of the committee was enunciated yesterday that there is no reservation of time afforded to any member. I recognize the gentleman from Wisconsin, Mr. Kassenmeyer, for purposes of general debate only and not to exceed 15 minutes.
Thank you, Mr. Chairman. The committee has, for the last virtually 8 months, been engaged in this quest for facts, evidence, and for truth. And up till now, the American people have been very patient. And, Mr. Chairman, I want to commend you for stating tonight that we will proceed inexorably to a conclusion of these deliberations, notwithstanding the Supreme Court's decision. For I do not believe the Supreme Court decision will have or should have any immediate effect on our committee's deliberations. It would have been helpful to have this evidence before, but we do not. We are prepared to accept the moment of truth, and hopefully, Mr. Chairman, we can conclude perhaps even this very week. This being, as far as the deliberations of the committee for many months is concerned, a concluding episode, I would like to take this opportunity to pay my respects to our professional staff. I am proud to claim that John Doerr and Richard Cates are from my home state of Wisconsin. And as well, I would like to pay my respects to Mr. Jenner from the neighboring state of Illinois. These and others who have so ably counseled us past months, I am sure long after this matter has been put to rest, that we are concluding in committee this week, can go to bed nights secure in the knowledge that they have been faithful to their conscience and to their country. Indeed, if those legal advisors to the President in former times had such a view, the President, this proceeding and other proceedings might not have been necessary. I would also say that as the general debate progresses and as the articles of impeachment are offered and debated, the specifics of the case against the President hopefully will emerge. But even then, in the several days and under the procedural limitations, we cannot hope to treat very much of the mass of evidence we have considered over these many months. However, the public is aware that these materials are now released publicly. Television, radio, newspapers, news magazines have attempted to communicate what this mass of evidence means. And while we here will have but a few hours of your attention in terms of the discussion of the implications of it, the public release of the materials should help the public even more. Mr. Chairman, we've labored long and hard in an effort to be fair to the President and to those among us who must sit in judgment but may not share common views. We now decide how to vote for or against impeachment. It is not our duty to attempt to assess whether Mr. Nixon committed common crimes. That is a determination which must ultimately rest elsewhere. In my own case, my decision has been made. I have concluded, after careful consideration of all the evidence, that President Nixon must be impeached and removed from office. I say this, whatever the record of the administration may be in other fields, notwithstanding. This decision was not reached lightly, nor was it made out of a personal animus toward the President. For the process of impeachment is a drastic undertaking, not only for the Congress but for the country, and cannot be taken casually. I would also have, as I have thought many times, if Mr. Nixon were the leader of my party, if Mr. Nixon were instead Mr. Johnson or Mr. Kennedy, and had been charged with the same offenses, could I freely and with as much certainty come to the same conclusion? I have to answer yes. I believe clear and compelling evidence does exist and leads inescapably to only one conclusion. President Nixon's conduct in office is a case history in the abuse of presidential power. The abuses documented by the evidence gathered by this committee are numerous and will be discussed hereinafter as they have in part been discussed before. I hope, too, that some of the issues and charges which may not originally be in articles before us, whether they are on the bombing of Cambodia or the presidential impoundment, be fully considered, and whether or not they constitute any final articles approved by this committee, they ought to be considered as a pattern of a whole in terms of presidential disregard for truth and for law. Mr. Chairman, it is important to draw a clear distinction between preserving the man and preserving the office. Mr. Nixon has consistently argued that this fight against the committee and the courts is designed to save the office. In fact, I would argue that this fight is designed to save one person, Mr. Nixon. Impeachment is the one way in which the American people can say to themselves that they care enough about their institutions, their own freedom, and their own claim to self-government, their own national honor, to purge from the presidency anyone who has dishonored that office. This power of impeachment is not intended to obstruct or weaken the office of the presidency. It is intended as a final remedy against executive excess, not to protect the Congress against the President, but the people against the abuse of power by a chief executive. And it is the obligation of the Congress to defend democratic society against
a chief executive who might be corrupt. Justice Brandeis warned Americans of the dangers of official illegality. Quote, "In a government of laws," he wrote, "existence of the government will be imperiled if it fails to observe the law scrupulously. Our government is the potent, the omnipresent teacher. For good or for ill, it teaches the whole people by its example. Crime is contagious. If government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy." End quote. Mr. Chairman, in my view, Richard Nixon has shown disrespect for the citizens of this nation, and he has violated their Constitution and their laws, engaging in official wrongdoing. Society, through its elected representatives, must condemn this conduct. Otherwise, we will cease to have a government of laws. I will therefore vote for impeachment of Richard M. Nixon, and I do this with the belief that the House of Representatives will agree, and that his trial in the Senate will result in his conviction and removal from office. Thank you, Mr. Chairman.
The chair is going to be compelled to recess for a period of time, and the chair will state that the meeting will resume at the call of the chair, but it's necessary that we do recess for a period of time. The cameras might be turned off during that time.
All right, so ends the first round of the impeachment debate, or at least the first round of tonight's part of the impeachment debate before the House Judiciary Committee. Jim, I would say that two significant things occurred during this opening portion. First, we had Republican Congressman Robert McCrory of Illinois, who indicated that he is ready to vote for impeachment on possibly two allegations, at least as I read the Republican congressman. And the other significant revelation, I thought, was Republican Congressman Henry Smith of New York, who indicated he will not vote for impeachment, that he is only unsatisfied about one part of the evidence as it relates to the secret bombing of Cambodia.
Which is not considered, Paul, a key area in terms of in realistic terms at least, a key area for impeachment, which made that even more interesting. It looks also, I don't know if you would agree, but it looks like the push to stop the proceedings while this matter of the tapes as a result of the Supreme Court decision today is not really gaining momentum. Of course, we can't tell, but Mr. Hutchinson, of course, the ranking Republican, said he favored that. McCrory really didn't speak on that issue completely. He mentioned it, but obviously he would favor that, I think. Henry Smith also favored that. And then, of course, the Democrats thus far have pretty well followed the pattern that they were supposed to follow. Mr. Donahue saying he was in favor of impeachment. Jack Brooks is for impeachment. And, of course, we just heard Robert Kastenmeier say he was for impeachment. And so we've had no real surprises thus far. Obviously, everybody is reading these things to pick up little nuances for shifts and changes. Let's go to Carolyn Lewis and see what she's picked up down there. Carolyn?
Hello. Yes, this is Carolyn. I'm trying to report to you that the reason that they've cleared the meeting room was that there was a bomb threat, and that's why the meeting was summarily dismissed. And if you notice, Chairman Rodino looked a little bit uptight when he dismissed everyone. There has been a bomb threat here at the impeachment proceedings, and that's why the chairman has cleared the room. They're now going to move in and try to check out the threat, and everyone was removed very, very quickly. Back to you, Jim.
All right, Carolyn, we can see on the camera that now that there are people still, the cameras, of course, are still on inside the committee room, and there you see an officer in there in uniform. looking around. There are other apparently Capitol Hill detectives who are also examining the room for the bomb threat.
We might mention, Jim, that there was a bomb threat when the Senate Watergate Committee had its hearings, and you remember on one occasion the committee room had to be cleared because of that.
Yeah. Public television coverage of the House Judiciary Committee debate on impeachment will continue in one moment.
This is PBS, the Public Broadcasting Service. NPAC's live coverage of the House Judiciary Committee's impeachment debate continues.
Back in Washington now, as you can see, the committee room is vacant, except for some law enforcement officers who are inspecting the room. There was an unexpected recess of the debate by the House Judiciary Committee on articles of impeachment as a result of a bomb threat. Chairman Rodino recessed the proceedings, and that's what we are awaiting now. The room has to be, of course, fully inspected and all clear sounded one way or another before the committee will continue. At this point, we have heard 1, 2, 3, 4, 5, 6, 7 arguments in this first general round of 15 minutes each. Let's go to Carolyn Lewis. Carolyn, did you notice any surprises other than the bomb threat?
Jim, yes, indeed. One of the Republican members that we all expected might be ready to vote for impeachment of the president was Henry Smith of New York. Now, if you noticed, he said that he sees no evidence at all that the president has committed an impeachable offense on any charge except possibly the bombing of Cambodia. That was enormously surprising because that's been one of the issues we didn't expect to be taken terribly seriously by the Republicans or the Democrats. You may know that Henry Smith is retiring this year, and he's hoping for an appointment by the Nixon administration. Whether that has had anything to do with his position, we don't know.
Carolyn, what did you make of McClory's statement? He also has been considered, of course, because he is the second-ranking Republican and has been very visible lately, also considered a key vote, whichever way he goes, particularly when it goes to the House, assuming that it does go to the House. How did you interpret his remarks?
He seems to be leaning for impeachment of the president, not on the issue of Watergate. Again, that's rather interesting. The reasons why people are leaning one way or another is really the surprise of this evening. But he seems to feel that the president has really insulted the Congress and has insulted the Judiciary Committee because he failed to provide evidence which the Congress demanded for the impeachment proceedings. And I think that could be a very, very serious charge, and I think it could be very dangerous for the president's chances if McClory does decide to go on that issue.
Let me ask both you and Paul Duke a question. You both have been watching these members of Congress, many of them at least, over several years now. It seemed to me that Peter Rodino, for instance, when he made his opening statement, he was much more eloquent than he was when this whole proceeding began 10 weeks ago. Same way with Hutchinson and Donahue. Do you think they've warmed to the task, the oratorical task?
I think it was quite obvious. I think two things were obvious tonight, Jim. Number one, I think that they were aware that television was there in all of its living color glory. And I think that additionally, beyond that, I think that they were aware that they were addressing themselves to one of the most historic proceedings which we can have under our constitutional form of government. And I think the importance of that was reflected in what they had to say tonight. It's quite true that Mr. Rodino was very eloquent in what he had to say. I think that all of these members, as they spoke tonight, it seemed to me, tried to speak in a statesmanlike vein. They tried to put the impeachment issue beyond partisan politics. I think, for example, it was Mr. McClory who said that as a Republican, he felt that he had to vote on the issue of impeachment not on the basis of what was best for the Republican Party, but what was best for the country. And as Carolyn indicated just a moment ago, Mr. McClory did make it clear that he felt the evidence was not really that strong in the area of the cover-up, at least insofar as the president directing and giving impetus to the cover-up, which, as you know, John Doerr, the committee counsel, had made much ado of in his arguments. But Mr. McClory obviously was disturbed about the president sanctioning wrongdoing in the White House or having some knowledge of wrongdoing by his aides. And he also was concerned about the president not faithfully executing the laws. Those things seemed to have considerable impact upon Mr. McClory. And he seemed to make it rather plain that he was ready to vote impeachment on those grounds. Jim, we have a news item which came in just a moment ago, which quotes the Democratic House leader, Thomas O'Neill of Massachusetts, as saying today that only a miracle can save the president. In an interview on National Public Radio, Congressman O'Neill said that he would now have to say that the president will be impeached by the House. Now, Mr. O'Neill is talking not just about the committee itself, but he is talking about the House of Representatives and suggesting that the president will be impeached by a minimum of 60 votes. And he goes on to say that there could well be a tidal wave that would hit the House, and he could be impeached by over 100 votes.
Was this interview granted, does it say, Paul, prior to the president's decision to give up the tapes or afterward, or we do know? Obviously, if it was today, it was after the Supreme Court, the original Supreme Court decision, but we don't know.
Yes.
One point of information for those of you who that the faces may be new in this inquiry, occasionally when the picture would go to John Doerr sitting at the council table, you'll notice he is flanked by two men. The man on his right is Sam Garrison, who is the new minority staff counsel. The man on his left is Albert Jenner, who was the staff minority counsel, and the man who now has become a member of Doerr's majority staff. There is not a lot of time there for either Paul or I to voice over and explain that. But so when you see that shot again, it's Albert Jenner on the left, Sam Garrison on the right. Let's go back to Carolyn Lewis on the Hill.
I think it's interesting to point out that while we've talked about a great deal of talk on constitutional issues, and you were getting that from the Democratic side, if you noticed, Edward Hutchinson, who was the ranking Republican, took it more to a political level, and he kind of made it plain that this was a political effort to remove the president. But probably more significant, Hutchinson did, in a rather mild way, ask the committee to please delay its proceedings on articles of impeachment until it manages to get the material from the court, which has been made available by the Supreme Court decision today. McClory also mentioned that, but again in a very mild form. And this, I think, would confirm that while the Republicans may make a gesture in the direction of demanding that there be a delay in the proceedings, they don't seem to be too anxious or too firm about it, and I think that means these proceedings will probably go ahead regardless of what happens as far as Jaworski getting the extra tapes, and of course as far as the possibility of those tapes being made available to the House Judiciary Committee is concerned.
Well, that touches on the very question which I wanted to put to you, Carolyn. Do you think that there is now a new Republican tactic of delay, that the president's staunchest defenders on the committee, members like Congressman Hutchinson of Michigan, working closely with the White House, will now try to use the Supreme Court decision as a method of dragging out the impeachment process all the more?
Paul, I think what they're going to do, first of all, is try to see if they can persuade the president to make the tapes available. Now, that would mean that they wouldn't have to delay. I think they're going to try to work from behind the scenes. As I said just a few moments ago, the way they handled this, it wasn't a very angry, demanding, it wasn't an effort really to sway the committee to delay everything. I think that at first they're going to try to persuade the White House to voluntarily hand over those materials and perhaps to do them quickly. I don't see at this early stage any sign that there is a concerted effort to delay the proceedings, even by the president's staunchest backers.
All right, thank you, Carolyn. A reminder that we are in recess. The House Judiciary Committee debate on impeachment is in recess as a result of a bomb threat. We are graced with the presence of the prominent Pulitzer Prize-winning historian Barbara Tuchman tonight. Ms. Tuchman, Henry Smith, the Republican congressman from New York, who made a statement a few minutes ago, said, and I quote, I think almost, that what these gentlemen are about to do will affect our nation for the rest of time. Do you agree with that?
Yes, I do. I think to go back to what we were saying at the beginning, that it's vitally important, as I see it, to begin to restore, so far as we can, if one can alter the course of history, restore the confidence of the citizens in their government, which I feel has been failing over the last period. Because when confidence in government fails, then then power loses authority, because authority is only effective so long as people believe in it. And I think this is a very dangerous situation to get into. And I think confidence in orderly government has sunk to a low, and that certainly I have not seen before in my lifetime. I think part of the plunge is, not all of it by any means, but of course the great plunge that we all see now is the responsibility of Mr. Nixon and his appointees, of whom, did somebody say 18 have been indicted? I thought it was 8 or 9 or 10 or 14 or 11 or whatever it is.
18 who have either been convicted or who have pled guilty to various crimes, and there are another 6 that are still under indictment for cases that have not been resolved. Now, that's not just White House officials. That includes also former officials of the committee to re-elect the president.
Well, all those people are, in the long run,
that's correct, is it not, Paul?
Presidential
I think that's correct.
appointees. And it seems to me this is one of the most serious aspects, because when you have 8 or 18 or whatever it is, staff members found guilty of wrongdoing, the presumption is not that the boss is an Eagle Scout. I don't see how it can be. It seems to me that this group of men are the appointees of the president, and he is responsible for them. And
at the opening of the program, you made the point, which you've reiterated somewhat, that Congress itself is also on trial as much as, say, the president is. Were you not then taken with the fact that these 7 men who have spoken thus far, that I would say all but maybe 1 or 2 made the same exact point, regardless of what the outcome of this is, that Congress itself is also on trial? Were you not?
I was. I think they feel it, the seriousness of what they said, except for Mr. Hutchinson, who seemed not to be purely acting on a Republican Party basis. But everyone else did seem, as Carolyn is her name, said at the beginning, it would have a solemn tone, and she was quite right.
Speaking of Carolyn, she has Congressman Wiggins with her. Carolyn?
Yeah. Congressman Wiggins, first of all, could you tell us whether you think there's going to be an effort to delay these proceedings because of the Supreme Court decision?
No, I do not. Our ranking member, Congressman Hutchinson, mentioned that in his opening remarks, but there's been no agreement, even discussion, serious discussion amongst Republican members. The only context in which a delay might have resulted was if the president had announced at 7 p.m. our time this evening that he was going to send post-haste material down to this committee, and then responsibly we should look at it and read it. But the court didn't order Mr. Nixon to send anything to our committee, and he didn't say he was going to do it. So absent some rather clear showing that we're going to get it, we obviously shouldn't wait unless we're waiting for something with the assurance that we are going to get it.
Are there any behind-the-scenes maneuvers to try to persuade the president to hand those materials over to the Judiciary Committee?
Well, they haven't been behind the scenes. I think they've been rather open. This member, and I'm sure other members, have exerted such influence as we have, and it turned out to be minimal, to get the president all along to send the requested materials down here.
Mr. McClory seemed to say this evening that he felt that it could be an impeachable offense that the president hasn't provided the materials to this committee. Do you think that that's a rather serious statement coming from such a senior member?
Anyone who says he might vote for impeachment is making a serious statement. But I'm not at all satisfied that Bob McClory will vote on that count once he's had an opportunity to reflect on the law.
You were wrong about Mr. Hogan, too, weren't you?
I realize that. I can understand his anguish and frustration, which I share,
about not getting materials which we requested. But the question that we have before us is whether the president is to be removed, not by reason of his contempt of Congress. He's never been held in contempt of Congress, but simply because he asserted, and I believe in good faith, that the materials were either not relevant or were covered by executive privilege. And to punish the president by removal from office on the basis of that bare assertion without an adjudication of the question of whether he is in fact in contempt, I think is pretty grossly unfair, I would think.
Hasn't executive privilege been struck down virtually now by the Supreme Court decision?
Well, the Supreme Court declared for the first time a rule of law today. Now, if the president acts tomorrow in defiance of that, that's a horse of a different color. But I don't think it's fair to punish any citizen for not anticipating in advance what the Supreme Court would do in a novel question never before considered by it. The decision today does not strike down executive privilege at all. It simply says that in the context of a specific criminal proceeding, then there can be an in-camera inspection by the court.
Do you think that Thank you very much, Mr. Wiggins.
Okay,
Thanks.
thank you.
That was Congressman Wiggins, California.
All right, thank you, Carolyn. Congressman Wiggins, as everyone probably knows by now, has been one of the president's most ardent defenders on the committee. I think on the basis of the discussion that was just finished between Carolyn and Congressman Wiggins, it might be well to read the president's words earlier this evening on this issue of confidentiality. He said, in saying that he was going to abide by the court ruling and saying that he was disappointed in the ruling, but he says, quote, "For the future, it will be essential that the special circumstances of this case not be permitted to cloud the rights of presidents to maintain the basic confidentiality without which this office cannot function. I was gratified, therefore, to note that the court reaffirmed both the validity and the importance of the principle of executive privilege, the principle I had sought to maintain," end quote. And of course, in the court's ruling today, what Chief Justice Berger said was that, of course, there was a right of executive privilege, but they said in this particular case that the right of executive privilege had to go second to the right of evidence in a criminal case, which was basically the ruling of the court. It did not, in essence, throw out executive privilege.
But in actual fact, I think, Jim, executive privilege was dealt a severe blow today, and this may have been a face-saving way of the president putting it, feeling that he was left something. But I think in the eyes of constitutional scholars, I think today's decision will be regarded as historic. I mean, it was, after all, an 8-0 verdict against the president. And it was established by the highest court in the land that the president does not have the right to withhold important evidence from a court of law.
Right, but the only point I was making was that the court only made this reference as it concerned criminal cases. I mean, for instance, let's use an example of executive privilege where there was a civil matter of some kind that did not involve litigation, maybe before a congressional committee or even in a civil court. I think it would be thin. Here again, I'm no constitutional expert. It would seem to me it would be thin to take this decision today and say executive privilege of all kinds has been struck down. What do you think about that, Barbara Tuchman?
I agree with you. I don't think of judging. I haven't even seen it, but just from what I've heard, it seemed to me that they specifically linked it to the necessity of a court requiring evidence in a criminal case. They didn't, I don't think, Mr. Duke, just simply rule it out. Mm-hmm. I mean, the fact of the unanimity is very impressive, and it's certainly gone against the president, and I think it will affect the whole mood of the Congress. But
yes, that's my point. I recognize the validity of what both you and Jim are saying, but nonetheless, the president has held, for example, that he had carte blanche, in effect, to withhold whatever he wished to withhold with the argument that there is presidential confidentiality under the Constitution which permits him to do this. And it seems to me the court was saying, no, that's not right. The president cannot do that. He is like any other citizen.
Right. They were upholding the primacy of the law over the individual, right?
Mm-hmm. but without throwing out completely the concept of executive
I would
privilege.
think so.
A reminder, of course, that we are in a break and a recess called by Chairman Rodino as a result of a bomb threat in the hearing chambers of the House Judiciary Committee, and we'll be back there shortly as soon as they give the all clear. Let's go now to Carolyn Lewis. Carolyn?
I have here George Danielson, a Democratic member of the House Judiciary Committee. Mr. Danielson, do you think there's any chance that the Republicans are going to succeed in trying to delay these proceedings, or do you think there's an effort to delay these proceedings until you get the Supreme Court evidence?
Oh, I'm sure there will be an effort made to delay the proceedings. I doubt that it will be successful, though. Most of us realize that if the tapes had something in them which would have been exonerative of the president, he would have produced them a long time ago. And if they do not, well, then we don't need any more evidence anyway. So I don't think there'd be any real purpose served by delaying.
Do you think that there are going to be a substantial number of Republicans voting to impeach the president? What's your feel from inside the committee at this hour?
Well, I have to get my feelings back in line since the Supreme Court decision. As of this morning, I thought we'd probably have a total vote of 26 or 27, which obviously requires some Republican votes. I don't know what impact the Supreme Court decision will have. It may change that a little bit.
In what direction?
Well, if some people may feel that, well, now maybe we should wait and listen to the tapes. That's a guess I'm making. We do a lot of this sort of just by, we sense it, shall I say, and I still think it's 26 or 27 votes, but I just want to let the effect of the Supreme Court decision soak in for a day or two on that.
If the president said that he would provide the tapes to the Judiciary Committee, but of course, as we know, the Supreme Court decision only gives it to Mr. Jaworski.
Sure.
If the president said he would provide those tapes to the committee, don't you think it would only be fair to wait and listen to them?
Well, I don't believe that we should wait any longer. We've been at it for so many months that I think the American people are probably way ahead of us. There's really no one going to be hurt if we do not wait. If the bill of impeachment is reported out, and if there's anything of value in there for the president, he can still use them. It's not lost. They could be used, for instance, in a Senate trial. As a matter of fact, if he's really got some information he wants us to hear, there's nothing to prevent him from publishing them tomorrow. You know, he published, 1,340 pages without asking anybody's permission. He can do that yet.
Mr. Danielson, on another subject, Henry Smith of New York said he would consider voting to impeach the president on the bombing of Cambodia.
Sure.
Do you think there's much groundswell for that particular article of impeachment?
No, I'm really surprised. That was a total surprise to me, and I might say it was a total surprise, I think, to everyone with whom I've spoken. It might be very interesting. Father Drinan favors it, and Liz Holtzman favors it. I don't mean that there aren't several who favor it, but hardly anyone has believed that there were the number of votes necessary to make it practical to include it as an account. Well, there are a number who favor such an article, but I don't think anyone dreamed that there would be 20 votes for such an article, nor that there'd be 218 on the floor.
Thank you very much, Mr. Danielson.
Pleasure to talk to you.
Thank you.
All right.
And we'd like to say for the record just once more that after all these weeks of deliberation, the House Judiciary Committee has had its first disruption caused by a bomb threat. And while the committee room is being searched and the committee members talk among themselves and with the press outside, we are merely proceeding with our own discussion here to bring you up to date on what has happened. There is a parliamentary development which has occurred inside the committee tonight, which is of some significance insofar as the impeachment debate is concerned. The number 2 ranking Democrat, Harold Donahue of Massachusetts, has moved to recommend that the president be impeached on the basis of 2 articles. The first would be a charge of obstructing justice, growing out of the Watergate case, the Watergate cover-up. The second would be that the president has abused his power, his presidential power, in a variety of ways. At the last moment, we understand, a third article charging Mr. Nixon with contempt of Congress for refusing to comply with committee subpoenas. This was merged into the second article. Now, by allowing this motion to be made tonight by the second-ranking committee member, Democrat Donahue, the chairman of the committee, Mr. Rodino, has established these two articles as the principal item of business in the impeachment process. They must be voted on before any other articles can be considered, and thus they represent crucial voting tests when they do occur. In effect, the motion that has been made by Mr. Donahue tonight is setting the agenda for the impeachment discussion for the remainder of the week. I think one of the things which is involved, Jim, in the drafting of these impeachment articles, and there have been little huddles involving certain key Republican members and certain key Democratic members. They've been taking place for the past few days. And they have been trying to reach behind-the-scenes agreement on how to proceed, on how to actually draft the articles of impeachment that would enlist the greatest possible bipartisan support. It is, of course, to the Democrats' advantage to get as many Republican votes as they can. They recognize the necessity of having substantial Republican support to not only clear articles through the committee, but also to help in clearing the articles when they reach the House floor. But one of the things they're now doing is drafting the language, and some Republicans, I understand, have taken exception to some of the language which was included in some of the articles drawn up by the committee counsel, Mr. Dorr, and some of the other members. For example, one of the articles referred to a malicious cover-up. Well, the Republicans are suggesting that you don't need to use such superlatives. You can merely say a cover-up and not use the adjectives to describe it.
Also, for instance, in the case of Congressman McClory, he made it very clear that he did not agree with John Doerr's drafted article of impeachment, the charge that the president directed the cover-up of Watergate from the day of the break-in onward. It's getting back to one of the points you made, it might be useful to point out what is considered the magic number in terms of there are 21 Democrats, and that they must be joined. What is it? If the word is that if 5 Republicans join them, this would ensure a much higher vote on the House floor. If 3 or less do, then the president considers that the president's chances of escaping impeachment on the House floor are increased, right? I mean,
well, I had an interesting conversation with a White House aide the other day who told me that if the president lost as many as 5 Republicans, the White House would have lost the ball game. If they lost as many as 3 Republicans, it would be a standoff. If they lost only 1 Republican, then it would be a significant victory for the president. Well, I understand that Carolyn Lewis is standing by again at the Capitol. Carolyn?
We've just had word, Paul, that they have searched the committee room and they have found no bomb, and very shortly we will be going back into the proceedings. They are going to be searching everybody as he or she goes in, so it may take a little bit of time for everyone to go inside. But they have found that there was no bomb in the committee room. It just was a bomb scare and a bomb threat. So that's one point of relief for us this evening.
All right, thank you, Carolyn. Barbara Tuchman, I noticed while Carolyn was doing her interview with Congressman Danielson a few moments ago that you seemed animated and wanted to comment on something that he said. Now is your chance.
Well, I was interested too in Representative Henry Smith's surprising remark about the secret bombing of Cambodia, because it always seemed to me from the start one of the most reprehensible aspects of the Nixon presidency, not only because he did it, but because he lied to the American public about it. And also because it brings up, again, this question of congressional responsibility and failure of responsibility, because I feel that it's going to take a great deal of responsible behavior by the Congress to wipe out the absence of responsibility on the question of war all through the last decade. The failure of the Congress to curb presidential war making when it is a provision of the Constitution that we cannot should not, cannot, I believe, make war without ratification of a declaration of war by the Congress. Now that is simply, we've been making war without that for quite a while. And the so-called Gulf of Tonkin resolution to me was, you know, a shameful blot on the record of Congress, of just saying to a president, go ahead, do what you like.
But that certainly made, of course that was during the Johnson administration, that certainly legalized the actions of the president, did it not? The Gulf of Tonkin resolution?
Well,
all practical.
It did in a technical sense, but what it really represented was Congress saying, look, we can't, we can't pass on this problem, we know nothing about it, you go ahead and do what you want, which is not what Congress is supposed to do in relation to the war-making activity of the nation, which is a very serious matter. And I think that's why I feel that both the power of the presidency and the balance between the power of the presidency and the power of the Congress is what is at issue, or if not at issue, but it's being played out here.
I think we should point out, Ms. Tuckman, that Congress has taken at least one small step. Some people think it's a big step, but however you may regard it, in that it has approved a war powers bill, which is designed to circumscribe the president's activities in leading us into war.
That's right.
And to compel the president to come to Congress to enlist the advice and the consent of Congress before American troops are committed in a foreign land.
The Javits Act.
Correct, correct.
The significant thing, of course, just in terms of the politics of this committee, of course, was that Henry Smith, a conservative Republican, raised this issue.
Yes.
As Danielson pointed out in the interview with Carolyn. It's been the anti-war people on the committee, primarily Father Drinan, Congresswoman Holtzman of New York. Those are the people who have been pushing the Cambodia bombing as a possible article of impeachment. And as Danielson said, up to this point, nobody thought it had a chance. It probably still doesn't have a chance, but it's, you know.
Well, as you suggested a moment ago, Jim, I think it's a curiosity that that Mr. Smith would mention this tonight, because it has not figured significantly in the debate, and I know of no one who has been in close touch with the committee who feels that the Cambodian bombing will be included as one of the articles of impeachment.
Well, maybe Mr. Smith really feels sincerely about
correct,
it.
Correct.
For once, a congressman might possibly be saying something that he just believes.
Could I ask you about the fundamental dispute which exists over what does constitute an impeachable offense? As we well know, and as we've heard many times in recent months, there is a broad view about what constitutes an impeachable offense, and then there's the narrow view, the broad view basically being that you take a comprehensive package of presidential misdeeds or wrongdoing and you have an impeachable offense. And the narrow view, of course, is that a president cannot be impeached unless he has committed a crime for which he could be convicted in a court of law. How do you see that argument?
Well, I'm not a constitutional lawyer, but I would say that an impeachable offense is abuse of power. And I don't think you need all this business of the smoking revolver. An elderly friend of mine who's in her 80s said to me, rather plaintively, is very puzzled about this talk about the smoking revolver. What do they want? She said they want to see a murdering Pat while robbing a bank. It's not that you have to have some overt statement by the president out loud saying, pay Mr. Hunt hush money. And it seems to me that he virtually said that in the tapes that we already have read. But to me, it's the entire body of the abuse of the office, the bringing it into contempt and lowering of the whole standard of the office of the presidency and its
Of course, in all fairness, we must point out that what you have just given is what is commonly referred to as the broad view of what constitutes an impeachable offense. That is held by, John Doerr and some of the Democrats on the committee. The other side of that is the narrow view held by the White House, of course, and some Republican members, which is that high crimes and misdemeanors should be taken in a literal sense, that the president must commit a criminally indictable offense. And of course you've just given the broad view. I think Chairman Rodino is back in his chair in the committee room now. There he is. The search for as Carolyn just reported, the search for the bomb proved fruitless, and I think we're now going to rejoin, and we will rejoin with the next man scheduled to speak is Charles Sandman, a Republican.
I think Mr. Rodino has just got up, Jim, and Carolyn is now waiting outside the committee room with Republican Congressman Trent Lott of Mississippi. Carolyn?
Mr. Lott, you met earlier this evening with Jerry Ford. Was there something very serious? He looked rather grim-faced when he met with you. Can you tell us whether you were leaning toward impeaching the president and he was trying to persuade you otherwise?
Well, we have a regular meeting on Wednesday afternoons of a group called Shouter and Marching. It's basically a social group of about some 47 members over several years. Jerry comes quite often, and we've had at least one meeting in his office. We discuss a variety of things, including some legislation before Congress. I don't think that if he left grim-faced, perhaps it was just that he was trying not to get in the position of having to say what might be said at 7 o'clock by the President's counsel. He did know he had not told us what would be said.
I'm talking about the meeting that was held upstairs in Mr. Glenn Davis's office
Right.
just momentarily. Was that a social meeting? It had nothing to do with these proceedings?
That was a meeting of a group called Chowder and Marching, and we meet every Wednesday at 5 o'clock and quite often in Mr. Glenn Davis's office, and the Vice President was there.
Mr. Lott, which way are you leaning?
Well, I'm one of those that's tried to keep a low profile, and I get very upset with my colleagues in the committee for making, I think, premature statements. There's just too much happening. I think we should wait till it's all said and done. Look what happened today. Maybe something else will happen tomorrow and change the whole direction of history, or the whole direction of this proceeding at least. I do not intend to make any profound statement before I vote. My vote will be my decision, and I won't announce it before then.
Do you want to delay this procedure until you can get the tapes that the president has to hand over to the court?
I might say that all of you have assumed quite correctly that my attitude has been the president was innocent until proven guilty with very clear and convincing evidence. So I'm sure your assumption that maybe I was leaning that way was a correct one. I don't know right now that I would want to say that the proceedings should be postponed. There are some things we can do. We can go on with this preliminary debate and then look at what happens. I think at some point we're going to have to hear this evidence and report to the House.
Thank you very much, Mr. Lott.
Okay.
Thank you.
Again, it should be pointed out for the record that Congressman Trent Lott of Mississippi is considered at this point, as he confirmed, in the against impeachment camp. The next speaker on the list, going by seniority, alternating Democrat and Republican, is to be, as I said, Charles Sandman, who is a Republican, is son of a Cape May, New Jersey milkman, and was defeated for New Jersey governor last year. He's been an ardent supporter of Mr. Nixon and is considered also, as is Mr. Lott, a probable vote against impeachment. As you can see, Chairman Rodino is once again in his chair. But there are some empty chairs there in the committee room. Apparently, some of the members didn't get the word that the bomb recess was over. That, of course, is.
But it looks like they've pretty well determined, Jim, that there was no bomb in the hearing room. I would like to refer for just a minute to the role of Gerald Ford, the vice president, in all of this, which Carolyn was just. She was just questioning Congressman Trent Lott about that. There is now quite a bit of speculation about the role being played by the vice president and whether he is now working for the president's cause in a diligent way behind the scenes. For example, it's been revealed that the vice president put in a phone call to Republican Congressman Hogan before he announced his vote yesterday.
Excuse me,
and now
Paul,
we go back to the committee room, and here is Chairman Rodino, who has just banged his gavel.
Well, that it was a secret bombing in another country. Where's Sandman? He was
secret in that country.
No, it wasn't secret in that country. It was secret in our country, where we, in an open society, where we have the Senate.
No, we
The
don't.
Congress has the Senate.
You and I, we can argue about whether or not there was a state of war, but it's a matter of...
There's Chairman Rodino on the screen. We didn't say too much about him as we started tonight. He's become a household name, joining names like Ervin and Baker from a prior proceeding related to this overall matter. Chairman Rodino, among other things, is the only poet and Italian opera lover on this 38-member House Judiciary Committee, and he is once again trying to start the proceedings again after the recess. Still some empty chairs.
The committee will be in order, and committee will resume its proceeding, and I now recognize the gentleman from New Jersey, Mr. Sandman, for purposes of debate only, for a period not to exceed 15 minutes. Mr. Sandman.
Thank you, Mr. Chairman. I'm not going to attempt to cover all of the charges that have been made. I'm going to isolate my statements to the major charge of the Watergate and Watergate cover-up. If it were not for that, I don't think we'd be here tonight. I think it's altogether proper, too, to commence by making a little bit of a review on what we've done, where we are tonight, and where we hope to go from here. My mind is unchanged as a result of the Supreme Court decision today. I believe that this committee should go on with its work. There are sufficient votes here for an impeachment resolution. This everyone knows. In fact, there has been that many votes here for a long time. There's no use kidding anybody about that. So regardless of what is in the new tapes, a majority does exist here to impeach the president for some reason or another. Now, I think that to say that this is the most unusual proceeding that I have ever been a part of would be a tremendous understatement. The thing that amuses me is it is important as it is, and even though it's been held in confidence behind closed doors, what I read in the papers from day to day lead me to believe I couldn't have been here. I must have been somewhere else. We started in closed session, and we swore by everything that was holy that we would uphold the rules of confidentiality. That has been the joke of the century. There has been nothing confidential in this committee. Members of the other side have reported to the media every hour on the hour, some every hour on the half hour. We have become the first forum in the history of man to release to the public every shred of information we have before a single decision was ever made. When did that ever happen before? Never. But we've done it. And then when we think about releasing information, I'm wondering, we have released tens of thousands of pages to the public and to the media to destroy if they choose, and some people in the media like to do that. And this involves hundreds of innocent people. Where was the American Civil Liberties Union about that? Isn't it strange that they have been remarkably silent? But willy-nilly, we have been willing, through one method or another, to give to the media, for whatever method they want to use it, every shred of evidence that exists. And most of it is not evidence. The interesting thing about this, too, is what happened the other day, just for example. One thing that apparently the media hadn't had yet was a large document that had 715 pages in it about miscellaneous documents. I was asked, and so were the other members of this committee asked, vote for this willy-nilly without the discussion of a single page or a single document. That's hardly the way you conduct a good hearing, is it? But that's the way we've been working. Fortunately, that was defeated. And now, another thing that happened the other day, I raised a question which I thought was a good one. I wanted to know whether or not counsel could advise me as to whether or not the articles of impeachment should be specific. Should each article involve a singular subject? I thought it should. Counsel never opened their mouth. We never got that far. And the chairman hit the gavel, and under the table that went. So there's never been a decision even on that point. And from the law, as I understand the law, the articles that we've been handed tonight don't fit what the law requires, because here you have a general article of impeachment, everything including the kitchen sink. And this, they say, from the best information available to me, from some of the best legal minds in the world, should not be. I wanted to know, but I got no answer. Now, I have consistently said from time to time that the chairman has done a good job, a fair job, and I think he has. I complimented the staff, I complimented counsel, both majority and minority, but there's never been really much difference between those two. And I meant what I said then as I mean it tonight. But things started to change 3 weeks ago. 3 weeks ago, it changed from a nonpartisan inquiry into a highly partisan prosecution, if ever there was one. Now, let's see what happened. Better than that, I suppose I should do away with current events and get down to why we're here tonight. And I hope that this has some advantage. I really do. I don't know if we're going to change any votes. I hope we do, one way or another. I hope it serves a purpose. I can be persuaded if somebody, for the first time in 7 months, gives me something that is direct, I'll vote to impeach, and maybe that should be the challenge to my 36 other colleagues tonight, 37 others. Now, I want to say this at the very outset. This is not a case, as far as I'm concerned, for or against Richard Nixon. I ran for governor in my state last year, and Richard Nixon didn't help me one blessed bit. So I have no reason to feel kindly toward him. Now, secondly, this is the third time in my life that I have had to vote on whether or not someone should hold a very high office. And I think because of the coincidence, it's worth telling you a little bit about it. The first vote that I cast in my life as a public official was when I was the youngest member, newly elected, of the New Jersey State Senate. The first vote had to do with the seating of a Democrat senator. And if there's anything I think I know, it's the New Jersey election law. I listened to all of the experts from around the country testifying. At that time, you only needed 11 Republicans to sign a petition, and that Democrat would never sit in the Senate. And we had 16, including me. I was the only Republican who voted to seat that Democrat. As a result of a long investigation, it proved I was the only Republican right. He was seated. 16 years to the day later, I cast my first vote in the Congress. And that was on the seating of Adam Clayton Powell. What a coincidence. It meant no difference to me whether his name was Powell, Nixon, or what it was. I voted my conscience as I understood the law, without the persuasion of the Washington Post and others. I voted as I understood the law. I was one of only 13 Republicans, and I did not want Adam seated. But under the Constitution, as I understand it, the Congress did not have the right to exclude him for the reason they set forth. I was one of only 13 Republicans who voted to seat Adam Clayton Powell, purely on a constitutional grounds. Only one of 13, and I may be one of less than that tonight, who knows? And more than that, who cares?
I'm doing this the way I think it should be done. This is the way I believe I pledged my oath of office. And although there were only 13 Republicans who voted to seat Adam, the United States Supreme Court said that only 13 Republicans were correct because they reversed the Congress and seated Adam. Now, for the first time in my life, I have to judge a Republican, the man who holds the most powerful office in the world, and make no mistake about that. I look back over history and I try to judge what I should do here. This is the most important thing I shall ever do in my whole life, and I know it. Far more important than whatever happens to me as a result of this vote. And I know history tells me that 107 years ago, the country was thrown into a fit of hysteria. And in less than 3 days, President Johnson was impeached during that fit of hysteria. That has gone down in history as one of the darkest moments in the government of this great nation. And I don't propose to be any part of a second blotch on the history of this great nation. How was it all done? The hysteria that was generated. Should it be done? Let's not use some words by some great people. Let's use all of them and put them together. James Madison, among other things, said that a president should be impeached only for something extremely serious, which affects his capability to conduct the affairs of the nation. And because of James Madison, a word was inserted into that part of the Constitution having to do with impeachment. He wasn't satisfied that it could be any crime because he said it had to be a high crime, a serious one. And this is what I think we have to follow. I'm not a nitpicker. You can find almost anything that will disturb you. There's lots of things wrong. There were lots of crimes committed by lots of people. But were they placed at the door of the president? I don't think so. But maybe you can convince me in the rest of the time that we have to argue, and if you do, I will vote to impeach, but not on what I've gotten so far. Madison said that the president should be removed only for the most serious offense. To do otherwise would deprive the electorate of the right to select. To do otherwise would place a mechanism in the hands of a majority party that any time they choose, they could throw the country into a turmoil to replace the chief executive, and that should never happen. So it shouldn't be any kind of a crime. It should be a serious crime affecting the chief executive's ability to rule the nation. Some people say we're here as a grand jury. I think we're here as much more than a grand jury because even Mr. Dorr has said, and I do compliment his ability as a lawyer, I think he's one of the best I've ever met and one of the fairest that I've met, too, up to 3 weeks ago. But even he said the weight of evidence must be clear, it must be convincing, and let's keep to those two words. You can't substitute them for anything else. Clear and convincing. Now, prove to me that they're clear and convincing, and I will vote to impeach. But you cannot and you should not, under any circumstance, attempt to remove the highest office in the world for anything less than clear and convincing, anything less than something highly serious. And this is what I propose to do. Now, many wrongs have been committed, no question about it. But were those wrongs directed by the president? Is there direct evidence that said he had anything to do about it? Of course there isn't. And what has happened in the interim? Fair articles like this. Reliable News magazine, I'm told. What does it say? And if this isn't trying to incite the people into a frenzy against good judgment, you tell me what is. Newsweek, July 22nd, 1974. The evidence, only half of an extremely damaging sentence.
It says, quoting the president, "I want you all to stonewall it. Let them plead the Fifth Amendment, cover it up, do anything, save the plan." Terrible, isn't it? They left off the other half of the president, as did that very fair Washington Post, when they buried on page 20 the other half of the sentence, which quoted the president as saying, "But I'd rather it be done the other way." This is what has happened every day, every hour on the hour. So we don't have to do this in frenzy. Let's do it the right way. The first tape of March 21, 1973, worried me to death. When I went to bed that night, I made up my mind the president is cooked. He doesn't have a chance. But the following morning, I heard another tape that was made only 3 hours later on the same day, and that completely did away with what was happening in the first tape. So you can't use one tape as this fair magazine has done. You can't use one part of a tape as the Washington Post did. You have to use it all in context to arrive at the truth, and this is what I suggest we do. Now, it is not the purpose of any media to make the news. It is the purpose and the objective of the media to fairly report the news. Now, to say, as this committee did over many weeks, everything that Haldeman knew, Nixon knew, that's not proof. And I want to pose this one last thing. I wonder what the prosecutor in the United States Senate is going to do for witnesses. I wonder what he's going to do. Is he going to plead his whole case on tapes because he can't use any of the witnesses we had? Because every one of them testified no act of wrongdoing on the part of the president. And if you don't think so, go through the lot. Who was the man who handled the money? LaRue. Was there any involvement by the president? His answer to the question, no. To the man who received the money, Bittner, the attorney. Did your client make any threat to get clemency from the president or any of his agents? The answer, no. As to the man who supposedly directed the payment of the money, Mitchell, did the president have anything to do with that direction? The answer, no. Now, with these kind of witnesses, how do you prove that case before the Senate? Is there a soul here who honestly believes that 67 out of 100 senators are willing to accept this kind of evidence? I don't think so. And I think this is why we're here. Now, maybe in the time that is remaining, someone, somehow, will point out the fact that I'm only human and I'm not infallible. Maybe I overlooked something. Maybe there is a tie-in with the president. All right, there's 37 of you. Give me that information. Give it to 202 million Americans, because up to this moment, you haven't. Thank you.
I recognize the gentleman from California, Mr. Edwards, for purposes of debate only and not to exceed 15 minutes. Mr. Edwards.
Thank you very much, Mr. Chairman. I always listen with keen interest to our eloquent colleague from New Jersey. I think that the facts with regard to the leaks are, of course, unfortunate, but I don't think it is really accurate to say that the leaks came all from this side. It has been made very clear by the press and by others that the faucet dripped from both taps, the hot and the cold. Insofar as the evidence that was released that my friend Mr. Sandman criticized, I voted against that too. But I think it should be pointed out that the President's counsel, Mr. St. Clair, was here. He was a part of all of these proceedings, and he recommended very strongly to the committee that this evidence be released. Mr. Chairman, there's been some mention made by some of our colleagues tonight regarding the Supreme Court decision, and I think that we should remember that the Supreme Court was very explicit in the decision. The evidence that will be released to Mr. Jaworski has only to do with the criminal trials that will take place. It will take several months, perhaps, for the production, the examination, the deciphering of these tapes. And then only the relevant portions to the criminal trials will be given to the special prosecutor. The remainder will be sealed and returned to the White House. Our needs with regard to this large impeachment inquiry are much wider. Our needs are much wider in scope than those of the special prosecutor and in the criminal case. And incidentally, our subpoenas still remain in effect, and we invite the White House, the President, to honor those subpoenas, and it certainly would make our job a great deal easier. And I think that the President should be reminded that the Supreme Court rejected his claim of absolute privilege. But, Mr. Chairman, this is one member who thinks that the welfare of the country dictates that we proceed deliberately, but with due speed in this undertaking that has been assigned to us by the full House of Representatives. And I would hope that the committee does not consider any delay because of the Supreme Court decision. Mr. Chairman, you and I and our 36 other colleagues and our splendid staff have worked here in room 2141 Rayburn for many weeks. We've learned much about the President and all the President's men, and indeed quite a lot about each other. More importantly, I think, we have relearned a lesson, and we are indebted substantially to Mr. Dorr, Mr. Jenner, Mr. Cates, and the fine members of the staff for this relearning process. This is a lesson that we were all taught in school and by our parents, and which we in turn try to pass on to our children. And it has to do with the value and beauty of our Constitution and the understanding that representative government, if it is going to work, requires that we all respect and obey the Constitution. And that means all 220 million of us. It's the compact we have with each other that enables us to live together in peace, to pursue happiness in raising our children and enjoying our friends. It requires that we treat one another with decency and respect when we're at work and when we're at school. It's the cement that holds us together as a decent and humane society. The President of the United States is also a citizen, just like the rest of us, and the Constitution applies to him also. In many respects, and that was pointed out earlier tonight, more so, because he has a lot more power than any of us has. Our founders recognized this. They recognized the frightening power that the President has, that we give the President, and the grave danger to the Republic should he abuse it. And so they very specifically inserted in this Constitution that he should be removed by Congress should he gravely abuse this power, and I emphasize the word gravely. Mr. Chairman, all our colleagues are dedicated people and excellent lawyers. Our committee, in its seemingly endless weeks of deliberations, I think behaved rather well, in accordance with the American traditions of due process and fair play. We invited the President's talented attorney to be a part of this process, to call his own witnesses, to question our witnesses, and to present every facet of the President's case. I agree with my colleague, Mr. McClory, that we can take some pride in our efforts to be impartial and fair. But we are divided on the question of whether or not President Nixon's violation of the Constitution threatened the American government the liberties of the people, and the Constitution itself. Yes, we disagree on whether or not the evidence supports the serious charges that are contained in this bill of impeachment that was delivered to each of us tonight. I would most certainly accept Mr. St. Clair's premise that a direct connection must be proved between the President and the alleged offenses. I strongly disagree, however, when he argues that the case against the President is based only upon inferences, one piled on the other. There I strongly disagree. Both Mr. St. Clair and Mr. Garrison insist that the only basis for this impeachment inquiry rests on whether or not the President was by intent a participant in the Watergate cover-up. These two fine lawyers should get high ranks from the President for their efforts to limit the scope of this inquiry, and certainly our job would be much easier if we could accept this thesis. Unfortunately for the President's defense, this is not the case, and the thousands upon thousands of evidence that we have reviewed in these past weeks etch a much broader picture. Indeed, a presidential course of constitutional misbehavior and abuse of power commencing only a few months after he was inaugurated for the second time and continuing until the present. Where then do I find myself? Yes, I have disagreed politically with the President for more than 20 years. Like my dear friend and colleague on my left, Bob Kastenmeier, I've had to subject my motives to the test of whether or not, if the shoe were on the other foot, if we were judging a Democratic president and one with whose views I agreed with, how would I vote? Well, I've searched my conscience. I've examined and re-examined the evidence, listened to the tapes, questioned the witnesses, listened to my colleagues, questioned the witnesses, subjected myself to the excellent briefings by the staff. I've tried to keep in mind the principles of the Constitution and due process. And I have made up my mind. And I don't make it up with, my decision is not going to bring me great joy. Mr. Nixon is a fellow Californian. He was a candidate for the Senate in 1950, and I was a supporter of his in 1950. There's an awful lot of personal and family tragedy involved in this whole thing. It's terribly unfortunate. So there isn't anybody on this committee that is going to be delighted with his vote to impeach. But I do believe, and this is the way I'm going to vote, that the President has consciously and intentionally engaged in serious misdeeds, that he has corrupted and subverted our political and governmental processes to the extent that he should be impeached, and the matter sent over to our sister body, the Senate, for trial to determine whether he is innocent or guilty. A number of my colleagues on the committee, a majority I think, and I are prepared to present what we think in the next few days is an overwhelming evidence to support this conclusion. On my part, I'm willing to face my constituents, my family, myself, and history with this sober conclusion. Thank you, Mr. Chairman.
I recognize the gentleman from Illinois, Mr. Railsback, for purposes of debate only, not to exceed 15 minutes. Mr. Railsback.
Mr. Chairman, thank you, and members of the committee. Let me begin by saying that you, Mr. Chairman, I think, in a rather difficult assignment, and although I haven't agreed with you, as you know, on many occasions, I think that you've handled yourself very well. And I think I can say for the most members of the committee that during these 6 months the 7 weeks of looking through the 38 volumes of evidence, the listening to the live witnesses morning, afternoon, and night, that I can be proud of my judiciary colleagues, most of them. I feel badly, as Charlie Sandman did, about the leaks, the selective leaks, some of which I think the newspapers made a mistake in playing, although I know they have a job to get the news. Let me say, Mr. Chairman, that I used to like to be on the House Judiciary Committee when we were worried about penal reform and juvenile delinquency, trying to improve some very important things in our country that needed improving. But I'm about to reconsider my assignment now that we've had amnesty, abortion, impeachment, and now a bomb threat. Let me say that I am one of those that has agonized over this particular inquiry. I think it would be difficult for me, frankly, to consider impeaching a Democratic president. I regard it as an awesome responsibility, one that I don't relish at all, one that is particularly difficult for me because we are considering impeaching a man, Richard Nixon, who has been in my district twice campaigning for me, that I regard as a friend, that has only treated me kindly whenever I've had occasion to be with him. I am not one of those that would try to demean his or derogate his record. In my opinion, Richard Nixon has done many wonderful things for this country, particularly in the field of foreign affairs, and someday the historians are going to recognize the contributions that he's made. Let me say that I've been asked by members of the press whether my arm has been twisted because I'm one of the 6 or 7 Republicans that have been undecided. And I can answer that with an unequivocal no, that the Republican National Chairman, George Bush, in my opinion, is one of the most decent, honorable men and one of the great national chairmen of this party. John Rhodes, who is the Republican leader of the House, has treated me only decently, honestly. Sometimes we've had differences of opinion. And I can say the same thing about my colleagues on this committee, the gentleman who sits to my left, who I regard as one of my best friends, except on the golf course, who happens to disagree with my views, I think, on this particular important matter. Let me say our job, as I view it, is to try to push aside partisan considerations, to try to be fair, to try to be judicious, to try to see that the President is afforded the same opportunities that have been afforded to other respondents in recent impeachment cases. There have been occasions when we've had substantial party divisions because some of us on the minority have not believed that the President has always been treated fairly procedurally. But I'll tell you, the end result has been the chairman, with some Democrats on the other side, has acquiesced and has usually ended up giving Mr. St. Clair the right to participate, the right to cross-examine, the right to call the witnesses that he wanted to call. I have 2 serious areas of concern in respect to the allegations of misconduct that have been leveled against the President. I will say unequivocally that I don't think a case has been made on the issue of the bribery charges on ITT, the bribery charges on the dairyman from the tapes that I've heard, the evidence that I've heard. I disagree with my good friend Henry Smith. I don't think that this president should be held to account for a bombing in Cambodia when those of you who have read The Best and the Brightest, the book by David Halberstam, have read probably the greatest indictment of the 2 previous administrations about untruths, distortions, statistics that were not accurate. But I do have some problems, and I want to share with my colleagues, I want to share with my constituents my concerns. They relate to what I would call the abuse of power. I can't think of an area where a conservative or a moderate or a liberal should be more concerned about the state of our government. On September 11th, John Dean called the Commissioner of Internal Revenue to his office, Commissioner Walters, where he submitted a so-called enemies list, which were McGovern contributors and McGovern supporters, and ordered the commissioner to audit those people. The commissioner didn't want to audit those people, resisted, said that he would have to check with Secretary Schultz. On September 15th, the president entered into a conversation with John Dean that began at 27 minutes after 5 and lasted until 17 minutes after 6. We have a tape recording of that conversation up until 6 o'clock. The other 17-minute segment has not been produced according to a subpoena. It's been subpoenaed by Jaworski. Judge Sirica was requested by Jaworski, the special prosecutor, to again listen to that 17-minute segment to see if it perhaps might not be relevant. The judge, in his reconsideration, determined that 13 of the 17 minutes were indeed relevant. According to John Dean's testimony, which has not yet been released but will be released, you will learn that according to John Dean, and I think John Dean knows that that tape is going to be made public, that the president knew about this ordered audit. It was his impression that he knew about it beforehand. The president made some derogatory remarks about Secretary Schultz and called him something like a candy ass. I didn't send him over there to be a candy ass. And John Dean was told to go back and if he needed any help to contact the president. If there is anything that's going to affect adversely our democracy, our individual freedoms, it's a misuse of a sensitive agency like the IRS or the FBI or the CIA. Let me just tell you a little bit about Watergate, what concerns me about the Watergate cover-up. On August 29th, the president held a news conference where he stated that he had had the Department of Justice, the FBI, I think it was the GAO, he referred to the Banking and Currency Committee, and he said that he had directed his own consul, John Dean, to investigate the Watergate to determine if there was any White House involvement. The truth of the matter is, as far as we know it anyway, the evidence, John Dean had never reported to him, had never been with the president. The White House logs show that. John Dean's testimony is to the effect that he didn't even know about such a report until the president's press conference. What was John Dean doing in the meantime? Well, for one thing, on June 19th, he was meeting with Mitchell, Magruder, and Mardian, at which meeting Jeb Magruder was told by John Mitchell that he ought to have a fire to burn some documents, incriminating evidence. Then on June 23rd, they decided, when it was reported to them that there was some money involved that had perhaps been laundered in Mexico, that money that had gone to the creep, what did they do? And the president knew about this. Get a hold of the CIA to determine if perhaps the CIA shouldn't influence the FBI not to pursue that because of covert activities. For a while, the CIA agreed to that. They did make an investigation. They found there was absolutely nothing to hide. They went back. Dean still persisted and wanted them not to interview witnesses that were relevant. What did they do on June 28th? They established John Dean and Ehrlichman and Haldeman. There's evidence that they established a fund using the president's consul Calmback to pay money, and I don't care what that money was paid for. I don't care whether you call it hush money or it was for defendants. The evidence is that then Pat Gray, on July 6th, the director of the FBI, was so incensed that after a meeting with Walters, he first called Clark McGregor, and then the president called him, and Pat Gray felt compelled to tell the president, some of your top staff are mortally wounding you. Then we go into the period after that. On September 15th, the president finally did meet John Dean, On the 15th, the president, after talking to Haldeman, congratulated him for plugging leaks and talked about containment and something to the effect of cutting losses or buttoning it up or something like that. Then you go into the next period, March 21st. Let me say that I don't think the president directed the payment of hush money, and I don't think we can make that allegation. But let me tell you what happened. The president on March 20th ordered John Dean. Things were beginning to get a little hot. The president on March 20th ordered John Dean to conduct a report, another report. This is the second Dean report. He says, that's right, this is the president speaking. Try just something general, like I have checked into this matter. I can categorically, based on my investigation, the following. Haldeman is not involved in this, that, and the other thing. Mr. Colson did not do this. Mr. So-and-so did not do this. Mr. Blank did not do this. Right down the line. Taking the most glaring things. If there are any further questions, please let me know. See? The next morning, John Dean advised the president that Ehrlichman was implicated, that Haldeman was implicated, that Magruder and Porter had perjured themselves, that John Dean himself was implicated. What did the president do at that point? Well, that afternoon, I won't say what he said about the hush money. They talked about the $1 million. They talked about the $120,000. It's important that we get that right away, isn't it? John Dean says it's important that we send a signal anyway. And so the president said, well, for Christ's sake, get it. Then there is another conversation, as my friend from New Jersey said, which kind of leaves that up in the air, however. But then later on that afternoon, again the president referred to a report that he wanted Dean to write. Only this time the president had knowledge of who was allegedly involved. And he says this, I don't want to get all that expletive, I'll say expletive deleted specific. I'm thinking now in far more general terms, having in mind the fact that the problem with a specific report is that this proves this one and that one and that one, and you just prove something, you didn't do it at all. But if you make it rather general, in terms of your investigation indicates that this man did not do it, this man did not do it, this man did not do it, and so forth. What happened after March 21st? The president ordered John Dean to go to Camp David to make a report. John Dean could not make that report. On September 5th, the president had a press conference. This was after everything had kind of blown up. The president, in his September 5th press conference, went back to the John Dean report and said, when it became apparent to me that John Dean couldn't make a report, I assigned it to John Ehrlichman, and this was March 27th, I believe. Now, what was the status of John Ehrlichman at that point? John Ehrlichman had already been implicated in the Watergate cover-up himself by John Dean on the morning of March 21st. John Ehrlichman denied that he had made any investigation at that point. Then we have John Dean blowing the whistle by going to the U.S. attorneys on June 8th, followed by Magruder on June 13th. Then LaRue, I think on June 14th, finally said on June 14th, the jig is up. Silbert, the U.S. attorney, called Henry Peterson, the head of the criminal division, and he said, Henry, we have broken the Watergate case. Henry Peterson contacted Kleindienst. Finally, this began the mid-April meetings with Henry Peterson. Now, what happened at those mid-April meetings with Henry Peterson? On April 16th, from 1:39 to 3:25, the president met with Henry Peterson. At this meeting, the president promised to treat as confidential any information disclosed by Peterson to the president. The president emphasized to Peterson, you're talking only to me, and there's not going to be anybody else on the White House staff. In other words, I'm acting consul and everything else. The president suggested that the only exception might be Dick Moore. When Peterson expressed some reservation about information, the president said, let's just better keep it with me then. In an afternoon conversation on that same day, a telephone conversation, when the president called Peterson, again he said, Henry, feel free to confide in me. I'm going to, in effect, keep it confidential. I know the rules of the grand jury. What did he do with the information that Henry Peterson gave to him? Henry Peterson, who was taking the place of Kleindienst as really the chief investigator in the Watergate case, The president on April 17th met with Haldeman, who had been implicated again by information that was given to Henry Peterson, and Henry Peterson had revealed it to the president, and the president advised at that point Haldeman that he better get together with John and map out some kind of a strategy on the money. Then there's a big deletion. I don't know what the material deleted is. Then he comes back and says, what about Kalmbach? Now what is Kalmbach going to say about the money? He says to Haldeman, you better get a hold of Kalmbach and tell him that LaRue is speaking freely. I just wonder myself, I'm concerned about the president's actions, not so much not about the break-in or what happened earlier.
The time of the gentleman has expired. I recognize the gentleman from Missouri for purposes of general debate only.
Mr. Chairman, I yield 2 minutes to my distinguished colleague and neighbor from Illinois, Mr. Railsback.
Railsback is recognized for 2 minutes out of the gentleman's time.
I thank the gentleman for yielding. Let me just try to finish very briefly. It was shortly thereafter that on April 24th and April 25th, and I believe on April 26th, that the president ordered Haldeman to listen to certain tapes that I think only he and Haldeman knew had been made in the White House. Haldeman listened to tapes that were made in February and March. He reported to the president on April 26th, and he spent, I think it was 5 hours with the president. We've subpoenaed that tape because we think it's relevant, and it's had support from both Republicans and Democrats, and that's one of the tapes where Haldeman was reporting to the president after spending 2 days listening to these tapes, which we don't have. I just can't help but wondering, when you put all of this together in that kind of perspective, I am concerned, and I'm seriously concerned. I wish the president could do something to absolve himself. I wish he would come forward with the information that we've subpoenaed. I just am very, very concerned. Let me just say one thing in the remaining minute. Some of my friends from Illinois, I've received all kinds of mail. Some of my people say that the country cannot afford, that we cannot afford to impeach a president. Let me say to many of these are good supporters and friends. Let me say to them, I've spoken to countless others, including many, many young people. And if the young people in this country think that we're going to not handle this thing fairly, if we're not going to really try to get to the truth, you're going to see the most frustrated people, the most turned off people, the most disillusioned people, and it's going to make the period of LBJ in 1968, 1967, it's going to make it look tame. So I hope that we just keep our eye on trying to get to the truth. Thank you.
Time of the gentleman has expired, and I recognize the gentleman from Missouri for the rest of his 13 minutes for general debate only.
I thank the chairman, and I thank my distinguished colleague from Illinois for his discussion, and I hope that history will record you received the clearest explanation of this problem on the time of the gentleman from Missouri. Mr. Chairman, it has been my privilege to serve on this committee for 10 years since I came to Congress, and never have I been prouder of this committee and the privilege of serving on it than I am during this period of its most supreme testing. For weeks, even months, we have studied evidence, heard witnesses, and debated the solemn question of impeachment. The time has come for decisions. Further delay is unjustifiable. The time-consuming task of impeachment must go forward. Should Richard M. Nixon be found guilty of obstruction of justice? Yes. Should Richard M. Nixon be found guilty of abusing the powers of his office? Yes. Should Richard M. Nixon be found guilty of contempt and defiance of the Congress and the courts? Yes. And on the last charge, he is a repeated offender. We hear a great deal today about the presumably grim consequences of impeachment: an endless public trial, a people divided, a government paralyzed, a nation disgraced. But suppose the House should decide not to impeach. This would have consequences too, and they deserve careful examination. Refusal to impeach would be a decision as momentous as impeachment itself. It would and could be interpreted as meaning that the Congress does not think Mr. Nixon has done anything to warrant impeachment. It would alter the historic relationship of presidential power and the constitutional system of accountability for using that power. Our message to posterity would be that Mr. Nixon had conceived and established a new conception of presidential accountability, and his successors could expect to inherit Nixon's conception of inherent presidential authority and wield unshared power with which he endows the presidency. Failure to impeach would be a vindication of a new theory of presidential non-accountability. Many would shrink from this trying constitutional responsibility. Shrinking from impeachment probably arises from remoteness of contemporary presidents, from the difficulty of visualizing offenses of this administration. Perhaps the situation is more easily conceived if put in more homely local terms. A letter of Robert P. Weeks in the Ann Arbor News did this well, I think, and I would like to paraphrase it. Number one, suppose your mayor approved a plan by which the chief of police of your city could illegally tap your phone, open your mail, burglarize your apartment, your office, or your house. Suppose your mayor directed your hometown police and FBI agents to tap the phone of the local reporter covering City Hall, directed the FBI to investigate a newscaster for the local radio and TV station. Suppose your mayor withheld knowledge of a burglary from a local judge trying a case in which that knowledge was important. Suppose your mayor secretly taped conversations held in his office in your city hall between himself and citizens like yourself, as well as public officials. Then, when a confirmed court order required him to turn over 9 of these tapes, refused to obey. Then reversed himself. Then announced 2 of the tapes containing the most critically important material did not exist. Suppose your mayor tripled his wealth while serving as mayor in your city. Suppose your mayor paid practically no income tax for several years because he claimed huge and legally dubious deductions for turning over his official papers to the local historical society. Suppose your mayor surreptitiously used city taxpayers' funds to make major improvements on 2 private homes he had. Suppose your mayor twice selected personally as mayor pro tem a man who had bribes delivered to him in City Hall, then resigned allegedly to avoid going to jail. Suppose your mayor selected and supervised as trusted top officials of his administration 10 men who were indicted, convicted, or pleaded guilty, including the city attorney. The citizens of your town wouldn't be complacent. Should we hold cities' elected officials to one standard of conduct but have a lower, lax standard for the president? Inaction will say to the president and future presidents, well, there's practically no limit to the improprieties we'll put up with in the White House. The Founding Fathers wisely made impeachment a constitutional remedy. They did not want to make it easy to get rid of presidents, but they were determined to make it possible. If we wish to restore the historic system of accountability of presidents, the means are at hand, and the time is at hand. If we do not hold Mr. Nixon and his successors accountable except once every 4 years, we license an imperial presidency, usher in a new and, I believe, ominous time for our republic. We transform the balance and character of constitutional order. Impeachment may have grievous consequences. Refusal to impeach will have disastrous consequences. The transcripts have diminished the president's image from that of a moral man surrounded by underlings who betrayed him to that of an amoral man who compounded his troubles by withholding more than a year the shocking truth about the mess he and his administration were in. He shows a lack of concern for morality, a lack of concern for high principle, a lack of commitment to high ideals of public office that make the transcripts a sickening exposure. Richard Nixon is humorless to the point of being inhumane. He is devious, he is vacillating, he is profane, he is willing to be led, he displays dismaying gaps in knowledge, he is suspicious of his staff, his loyalty is minimal. His greatest concern is to create a record that will save himself and his administration. The high dedication to grand principles that Americans have a right to expect from a president is missing from the transcripts. I do not know how one of sound mind can read the transcripts and continue to think Mr. Nixon upheld the standards and dignity of the presidency which he proclaimed himself as a candidate in 1960, 1968, and 1972. Involved here is not a question of Democrat or Republican, liberal or conservative, or of a conspiracy by his enemies to get the president. In the words of an old senatorial friend and presidential defender, Mr. Nixon took a principal role in a shabby, immoral, and disgusting performance. This is a matter of right or wrong, telling the truth or not telling the truth. Perhaps an old Missouri saying is appropriate. If the Lord loved a liar, he'd hug him to death. The issues here are broader than criminality. An individual's conduct may be indefensible and reprehensible without being criminal. Legal, constitution, and parliamentary history show an official may be removed for failing to do his job. Many would shrink from this trying constitutional responsibility. Shrinking from impeachment probably arises from remoteness of contemporary presidents, from the difficulty of visualizing offenses of this administration. Perhaps the situation is more easily conceived if put in more homely local terms. A letter of Robert P. Weeks in the Ann Arbor News did this well, I think, and I would like to paraphrase it. Number one, suppose your mayor approved a plan by which the chief of police of your city could illegally tap your phone, open your mail, burglarize your apartment, your office, or your house. Suppose your mayor directed your hometown police and FBI agents to tap the phone of the local reporter covering City Hall, directed the FBI to investigate a newscaster for the local radio and TV station. Suppose your mayor withheld knowledge of a burglary from a local judge trying a case in which that knowledge was important. Suppose your mayor secretly taped conversations held in his office in your city hall between himself and citizens like yourself, as well as public officials. Then, when a confirmed court order required him to turn over 9 of these tapes, refused to obey. Then reversed himself. Then announced 2 of the tapes containing the most critically important material did not exist. Suppose your mayor tripled his wealth while serving as mayor in your city. Suppose your mayor paid practically no income tax for several years because he claimed huge and legally dubious deductions for turning over his official papers to the local historical society. Suppose your mayor surreptitiously used city taxpayers' funds to make major improvement on 2 private homes he had. Suppose your mayor twice selected personally as mayor pro tem a man who had bribes delivered to him in City Hall, then resigned allegedly to avoid going to jail. Suppose your mayor selected and supervised as trusted top officials of his administration 10 men who were indicted, convicted, or pleaded guilty, including the city attorney. The citizens of your town wouldn't be complacent. Should we hold city's elected officials to one standard of conduct but have a lower, lax standard for the president? Inaction will say to the president and future presidents, well, there's practically no limit to the improprieties we'll put up with in the White House. The Founding Fathers wisely made impeachment a constitutional remedy. They did not want to make it easy to get rid of presidents, but they were determined to make it possible. If we wish to restore the historic system of accountability of presidents, the means are at hand, and the time is at hand. If we do not hold Mr. Nixon and his successors accountable except once every 4 years, we license an imperial presidency, usher in a new and, I believe, ominous time for our republic. We transform the balance and character of constitutional order. Impeachment may have grievous consequences. Refusal to impeach will have disastrous consequences. The transcripts have diminished the president's image from that of a moral man surrounded by underlings who betrayed him to that of an amoral man who compounded his troubles by withholding more than a year the shocking truth about the mess he and his administration were in. He shows a lack of concern for morality, a lack of concern for high principle, a lack of commitment to high ideals of public office that make the transcripts a sickening exposure. Richard Nixon is humorless to the point of being inhumane. He is devious. He is vacillating. He is profane. He is willing to be led. He displays dismaying gaps in knowledge. He is suspicious of his staff. His loyalty is minimal. His greatest concern is to create a record that will save himself and his administration. The high dedication to grand principles that Americans have a right to expect from a president is missing from the transcripts. I do not know how one of sound mind can read the transcripts and continue to think Mr. Nixon upheld the standards and dignity of the presidency, which he proclaimed himself as a candidate in 1960, 1968, and 1972. Involved here is not a question of Democrat or Republican, liberal or conservative, or of a conspiracy by his enemies to get the president. In the words of an old senatorial friend and presidential defender, Mr. Nixon took a principal role in a shabby, immoral, and disgusting performance. This is a matter of right or wrong, telling the truth or not telling the truth. Perhaps an old Missouri saying is appropriate. If the Lord loved a liar, he'd hug him to death. The issues here are broader than criminality. An individual's conduct may be indefensible and reprehensible without being criminal. Legal, constitution, and parliamentary history show an official may be removed for failing to do his job, or for bringing scandal and disgrace to his office, losing his ability to govern effectively. The distinguished gentleman from New Jersey, Mr. Sandman, mentioned James Madison. And on May 19th, 1789, in the debates in the Congress concerning our Constitution, Mr. Madison said, quote, "I think it absolutely necessary that the President should have the power of removing his subordinates from office. It will make him in a peculiar manner responsible for their conduct and subject him to impeachment himself if he suffers them to perpetrate with impunity high crimes or misdemeanors against the United States, or neglects to superintend their conduct so as to check their excesses." It is true this standard, this action may tempt opponents to seek removal of a president for political or otherwise inadequate reasons, as some believe they did with Andrew Johnson. But that risk must be accepted. The ultimate arbiter is the people. Public reaction today is clearly revulsion. Republican politicians defect from Mr. Nixon in droves. The evidence against Mr. Nixon is, in his own words, made public at his own direction. There can no longer be a charge he was railroaded out of office by vengeful Democrats or a hostile press. The fundamental questions have been answered. Filling in gaps in the transcripts only make the case stronger. Let's assume for a moment you were President of the United States, March 21st, 1973, and possessed of normal standards of honesty. One of your assistants comes to the office and says, "Mr. President, you remember the burglary at the Watergate? We are spending your campaign money to take care of the families of the men caught in that burglary and to pay their legal fees." What would you say? What would you do? Would you examine all your options? Would you say that would be perfectly legal, as Mr. Nixon has subsequently said of such payments? Or would you say something like this: that money was raised to re-elect the President of the United States. Nobody in this office is going to use it to support burglars. You know, a man who is not a crook is not necessarily an honest man. We do not have to find Mr. Nixon guilty of a crime in order to find him unfit for this high office. Ask yourself the question, what would I have done if I learned funds given to me by people who believed in me and wished to secure my re-election were being used to support burglars? Would I have said, that would be perfectly legal, and kept quiet for 40 days? Now ask yourself whether you think Richard Nixon is worthy to occupy the highest office in the gift of the people, and it's their office. It's hard not to appear silly, you know, or dishonest when circumstances conspire to make you play two roles or speak about the same subject from opposing points of view. So with the President Nixon and the Watergate. It's reasonable for a man trying to run a government to insist that 1 year of Watergate is enough. It is reasonable for a man suspected of jailable offenses to do what he can to keep the prosecution from being able to prove what it suspects. But when administrator and suspect are one, it's hard to say anything without the appearance of self-serving dishonesty. As a result, Mr. Nixon is forever saying contradictory things. For instance, he is cooperating fully with the committee and the special prosecutor, even while he is denying documents and denying tapes that the prosecutor and this committee seek. Well, there's a way out. He could plead the Fifth Amendment. President Grant did during a congressional inquiry. And add to this the fact that he is presumed innocent until proven guilty, and you have perhaps the best defense that he might make. You know, the President spoke a lot about law and order in his day. Mr. Nixon said at Miami Beach in '68, it's time for some honest talk about the problem of law and order in the United States. If we're to restore order and respect for law in this country, there's one place to begin, we are going to have a new Attorney General of the United States. Well, you know, one day we had three, one every 15 minutes there. He says, Mr. Nixon says, I pledge to you that our Attorney General will be directed to launch a war against organized crime in this nation. Government can pass laws, but respect for law, Mr. Nixon says, can come only from people who take the law in their hearts and minds and not into their hands. Mr. Nixon said in '68, I believe in a system in which the appropriate cabinet officer gets credit for what goes right and the president takes blame for what goes wrong. Mr. Nixon said in '68, I believe in any system of government providing a method for peaceful change. There is no cause justifies breaking the law or engaging in violence. Mr. Nixon said in '73, March 14th, the only way to attack crime in America is the way crime attacks our people, without pity. Mr. Nixon said in '71, one final point, you talk about a police state. Let me tell you what happens when you go to a real police state. You can't talk in your bedroom. You can't talk in your sitting room. You don't talk on the telephone, Mr. Nixon says. You don't talk in the bathroom. As a matter of fact, you hear about going out and talking in the garden. I've walked many times through gardens where I had to talk about something confidential. You can't even talk in front of a shrub. That's the way it works, Mr. Nixon said. I'm simply saying this, my friends. There are police states, but we don't want that to happen in America. And as long as I'm in office, we're going to be sure that not the FBI or any organization engages in such activity. It goes on. On this committee, we're all lawyers, and to become lawyers, we took the same oath to uphold the Constitution that Richard M. Nixon took. To become congressmen and congresswomen, we took the same oath to uphold that Constitution which Richard M. Nixon took. If we are to be faithful to our oaths to support the Constitution, we must find him faithless in his.
The time of the gentleman has expired, and the committee will recess until 10 o'clock tomorrow morning.
What about it, Rocky?
And so ends tonight's opening round of the impeachment debate before the House Judiciary Committee. First such debate to take place before a congressional committee involving a president in more than 100 years. There were two dramatic and significant moments tonight during the opening round of discussion involving the 38 members of the Judiciary Committee. Both of these involved Republican congressmen from Illinois. The first came when GOP Representative Robert McClory of Illinois, who has been regarded as a fence-sitting GOP member, indicated that he is now tending toward voting for articles of impeachment that involve an article of abuse of power. Then a bit later, just a few minutes ago, we heard an impassioned speech by Congressman Tom Railsback, also from Illinois, who almost assumed a prosecutorial role in detailing many of the events that have tended to implicate the president in the Watergate case. Railsback stopped short of saying that he would actually vote for impeachment, but he certainly left a rather strong impression that he may well vote for impeachment. This could mean that at least 3 Republican members of the Judiciary Committee are now prepared to vote for articles of impeachment, but we still have to hear from 11 of the 18 GOP members who are yet to speak. And it is entirely likely that some of the Republican members who have not yet spoken also will indicate that they will vote for impeachment. As we have said before, most of the Democrats have indicated that they are ready to vote for impeachment. And in the eyes of many people, the Judiciary Committee, when it does wind up this debate, will approve a resolution of impeachment that will embrace 2 or perhaps 3 articles of impeachment against the president. I did think, Jim, that tonight the debate was conducted on a rather high level. I think that most of the members who spoke were aware of the historical impact that they were having as this was taking place on American television.
Well, I would agree, Paul. What struck me, of course, is the obvious thing of the differences in the style of these styles of these various congressmen. Some of them took the statesmanship approach. Others became prosecutors. Others, for instance, Congressman Sandman of New Jersey spoke almost like in a after-dinner speech, almost an informal type of of style. I think that once again you have to be struck with the basic concept of criminal justice when you're listening to a criminal trial, where you have people who hear the same evidence and come up with two entirely different conclusions. And we saw this tonight. Let's go to Carolyn Lewis on the at the Judiciary Committee hearing.
Honestly, when I didn't have time to prepare a written statement, I decided that I would wing it with just some references to different materials that I had.
They're telling me we have 30 seconds, so let me just ask, you almost came to the brink of announcing your vote. Will you now?
I'm going to listen to all of the debate, and I think all of us are really taking it seriously. I want to hear what the other members have to say, too.
Thank you very much.
Mr. Rasbach, could you stay with us? We're still on the air. Mr. Rasbach, from what you said, you've made a very deep study of the evidence. Do you feel at this point, at least, you're leaning for impeachment of the president?
What I wanted to convey is that there are some very, very serious questions which I think really have to be answered, and I hope I also conveyed my concern that the White House has really not cooperated. In other words, it's very clear to me, after I really did study the evidence and I've worked hard, it's very clear to me that some of those tapes that we've subpoenaed with bipartisan support, in other words, some of those tapes had overwhelming Republican support, that they are relevant. And I just hope, I meant what I said. I wish that the president would come forth with whatever he has and be candid and let's get this thing over with. Let's get to the truth. That's what the American people want.
Was this then a warning that you were issuing on public television here?
Listen, I've issued a lot of warnings, and I'm not in a position to warn anybody. I'm one member of 38 members on the committee that happens to be deeply concerned, that would like to give the president the benefit of the doubt, but is having difficulty giving him the benefit of the doubt.
But Mr. Railsback, you don't realistically think that there's any chance now that the president's going to step forward and do what you've suggested?
Yes, I do. I think the fact he's been ordered to turn over the 64 tape conversations to the special prosecutor, I think the committee ought to ask him at the same time to make, at least of those, make copies for us. I think he ought to go even further. I think he ought to turn over the other materials as well.
We've just been talking to Congressman Railsback.
Thank you, Carolyn. Carolyn Lewis, our Capitol Hill reporter, who has been on the scene. Well, what have we learned tonight? Well, we had 11 members who spoke up. There were 6 members, all Democrats, who indicated rather plainly that they will vote for impeachment. We had 2 who indicated that they will vote against impeachment, and they were both Republicans. And then we had 3 who also were Republicans, who indicated that they could vote, they didn't say definitely, that they could vote for 1 or more articles of impeachment. Now, Jim is at a tote board, tote board, which we have rigged up here in our studios to give you some clearer conception of how the committee does line up and how the vote may proceed and just what may happen when they do finally get around to voting articles of impeachment. Jim?
Paul, this board reflects where the best guesses were, at least when the day began today, as to where, or for ayes for impeachment, 19 votes. That's 18 Democrats and 1 Republican, Congressman Hogan of Maryland, who announced yesterday that he would definitely vote for impeachment. The nays, all Republicans, 7. 5 maybe nays, all Republicans, and 7 maybe ayes for impeachment. Break down 3 Southern Democrats and 4 Republicans. Now, what I want to do now, with your help, Paul, and Carolyn's help, to see if we need to make some changes based on what happened today, and particularly what we heard tonight. I would think that the ayes would remain the same. Any disagreements there of the people we heard tonight, Kastenmeier, Edwards, Brooks, Donahue, and Hungate, they pretty well confirmed their position, so there'd be no changes there. Would you agree?
I agree.
Carolyn?
Congressman McClory, earlier this evening you indicated that you might very well vote an article of impeachment on the president, particularly on the grounds that he has refused to hand over evidence. Am I correct in summing up that that's the way you're leaning?
Yes, I feel very strongly that the President should comply with our subpoenas and actually furnish all of the materials that we requested. And since he refused, why I feel that some action should be taken. And it is a valid ground for impeachment, I think, that the President has, in a sense, defied the Congress by refusing to provide the information that we have required in connection with our investigation. Now, since the Supreme Court decision, it seems to me that this provides added grounds for this proposed article, and I'm hopeful, on the other hand, that the President and his counsel will see fit to deliver the materials to us without having to take action by way of impeachment.
You're a senior member of this committee. Do you plan to go into some kind of negotiations with the White House, perhaps through Jerry Ford, to try and get that material?
Yes, I was rather surprised that the White House, neither Mr. St. Clair in his earlier announcement nor any other information forthcoming from the White House did include a mention of delivery of this material to our committee, because it seems to me that we have even a superior right to the information than that of the court. But I know that Mr. McCahill, Mr. St. Clair's assistant, was in the hearing room here this evening, and if I don't talk to Mr. St. Clair, I'll at least talk to Mr. McCahill or have one of our counsel talk with him and see if we can't get the material we require. Now, if it could be forthcoming within a period of a few weeks or a month, I would say definitely that we should delay any final report to the House of Representatives in order that we have this fuller information.
Thank you very much, Mr. McClory. Thank you, sir.
Carolyn.
Well, our intrepid reporter, Carolyn Lewis, has done it again. She has just drawn from Congressman McClory a further statement which now seems to imply that he most definitely is prepared to vote for one or more articles of impeachment. So, Jim, I think you should change your tote board there.
All right, yes. McClory is now, or when the day began, was considered a maybe nay. Are we saying put him down into a maybe aye at this point, right? At least on the issue of subpoenaed evidence. All right, any more changes in the nays? I'd say no. There's 7 all Republicans. The 2 men who spoke tonight, Edward Hutchinson and Charles Sandman, certainly confirmed their position. Sandman did say if somebody demonstrated in a very graphic way the smoking gun theory, at least, that he would vote for impeachment, but the chances are he will not. Okay, on the maybe nays, we've lost one, McClory and Smith. I would say Smith would have to be classified as a nay now, would you not?
I would, very definitely.
All right, because he pretty well said nothing except the Cambodian bombing, and that is probably not going to get off the ground in a serious way, so we have that change. That leaves these 3 gentlemen, David Dennis, Wiley Main, and Harold Froelich, all Republicans on the maybe nays. All right, on the maybe ayes, what about Tom Railsback? He's the only other one down here who spoke. We just heard him again. I guess he would have to stay in that same category. He certainly did not say he was definitely going to vote for impeachment, at least even though he gave strong indications. Any other changes that you would make, Paul?
I think that does it, Jim.
Okay.
Now we would like to go back to Barbara Tuchman and ask you for your impression of tonight's debate, Ms. Tuchman.
Well, I was struck by one remark in the gentleman from Missouri, Hungate?
Mr. Hungate.
When he just happened to say that the kind of conduct that the American people have a right to expect. I think this is a very basic issue in this whole business. What we expect, what we have a right to expect of our institutions, and it seems to me we are in an era where perhaps our institutions, and not only government, are not working in the way that we have in the past expected. And I suppose I shouldn't draw the analogies from the Middle Ages. I have a tendency lately to do this all the time because I'm working on a book on the 14th century, but at the moment it's so striking that I would like to make the comparison because the 14th century was a period which, to put it in the words of a famous historian, was a bad time for humanity. for various reasons, plague and war and violence and disillusion. And I find it very similar to the 20th. And one of the fundamental troubles was that institutions that people had believed society was organized in weren't working the way they expected. As you know, in those days, the political structure was based on the so-called three estates, which people assumed God had arranged as permanent orders of society: the clergy, the nobles, and everybody else, the commoners. And the clergy was supposed to each had a function for the good of the whole. That was the theory. The clergy would pray for everyone and communicate between lay society and the divine, and the nobles would fight to protect the church, avert the oppression of the poor, uphold virtue, and combat tyranny. The commoners would work so that everybody could eat. That is, they would till the soil, they would provide commodities of life through trade and commerce. But the first two orders, by this time, were simply not performing their functions in a way that people had any confidence in, because the church had become, I'm afraid I'm going on now too long on something that has nothing to do with tonight's, except in a larger sense it has to do with it. The clergy, the church, the whole hierarchy from pope right down to priest had become held in contempt and corrupt and sunk in a kind of degree of worldliness and monetary values that destroyed all spiritual power. The nobility, the knights who were supposed to fight and protect the people, were doing anything but. They were the real oppressors. They were committing violence that was destroying all goods and all security. And to wrap this up quickly, the confidence in the institutions, the orders of society was simply disintegrating. And this caused tremendous upheavals and revolts and revolution and distress and violence and psychological torment. And people themselves then failed to behave because they saw no proper conduct on the part of their so-called betters. Well, I know it seems far-fetched to relate this, to use this as an analogy to the present, but that's the way I see it. I think we have, for very good reason, lost confidence in the people most people want to look up to, whether we do any
And that is the president, obviously.
Well, more than that.
Well, we want to thank you for coming here and appearing and taking part in our discussion, Ms. Tuckman. Jim, we've had the first round tonight, and I must say that I certainly was struck by that, just sitting in on this great moment of history as it took place. We had 11 members of the Judiciary Committee who spoke tonight. Tomorrow we will hear more members, and the debate will proceed tomorrow morning.
And it will proceed with the President's most ardent supporter, Charles Wiggins, first in order, be followed then by John Conyers, probably one of the President's most severest critics, the Democrat from Detroit, Michigan. We will also be back tomorrow night at 7:30 Eastern Time. If the committee is still in live session, as it is expected to be, we will pick it up live and then give you a videotape replay at the following of that of the daytime session, which does begin at 10 a.m. Eastern Time. Again, our thanks to Barbara Tuckman. For Paul Duke and Impact, I'm Jim Lara. Thank you and good night.
From Washington, you have been watching live gavel-to-gavel coverage of the House Judiciary Committee proceedings. Production funding provided by public television stations, the Ford Foundation, and the Corporation for Public Broadcasting. This has been a production of NPACT, a division of GWETA.